And it would be good for those who are not familiar with what um, an employee assistance program does, if you could just give us a paragraph on what the purpose is of that program.
Mr. Chairman and members of Division 3 House Finance, for the record, my name is John Williams. I'm the Director of Legislative Affairs for the New Hampshire Department of Health and Human Services, and with me today is
Thank you. I'm Michael Lawless. I'm the director for the state of New Hampshire's Employee Assistance Program.
and Mr. Lawless will proceed in addressing your initial question or request for a high-level brief overview of what this program would do.
So, employee assistance programs are really designed to support employees with whatever challenges that they may be dealing with in the workplace or even outside of the workplace. It's not intended to be long-term services. They're brief in nature. Um, there can be an educational component, but for the most part, what it really entails in brief is an assessment of some of the challenges that the individual is dealing with, maybe some resources or connecting with resources out in the community in those specific areas.
In the corporate world, um, the other thing that I think happened in employee assistance programs, it was also gave some insight into the health and welfare of the workforce. And if there were unusual stresses building in the aggregate, to inform management that there may be some systemic issues that should be addressed. Does our state EAP do anything like that?
Our EAP is really a robust program in that it works with individuals with their individual needs, but there are also places for workplace interventions, um, work culture audits, just a variety of supports and services to impact the employee health and wellness, as you mentioned, but also in some circumstances, depending on how the ask comes in, because it really holds the confidentiality of each individual accessing our services. But in some instances, those asks are directly related to the workplace. And so, in that way, the recommendation would be for the workplace.
All right, thank you. I'm not sure I phrased my question properly. What I'm looking for is whether or not our EAP summarizes the aggregate overall health and welfare of the body to provide overall situational awareness. Of course, individual privacy is maintained, but if there are some general workforce trends that are of interest, is that something that is separately culled out and reported?
We're moving to a data management system that's just been approved, and that's going to allow us to see in a larger way trends impacting the overall functioning in departments. For now, the way those requests have been handled is on a case by case basis, a department by department basis.
All right. Are there any questions, Representative Mooney?
Thank you, and thank you for being here today. So in the methodology of the fiscal note, it mentions per person cost, et cetera. Does this bill mean that it's entering a scenario whereby there's a per person cost for all 424 legislators, even though maybe 50 would use the service? Is that how I'm reading this?
That is correct. The cost allocation formula, the number is low per person, taking into account that fact that not all 424 would likely utilize it. But I would also add that that also brings into the ability of each legislator, if it were to pass, members of their household would also be able to access the resource.
Okay, that was really a great detail because that had eluded me, that family members are eligible to use the EAP as well if the benefit is provided. Okay,
That's
question?
Yes, thank you for coming and thanks for taking my question. Um, so the 38, if nobody used it, would we pay zero? Or we pay a fixed amount per person regardless of whether, so that's what you were saying there. Okay.
Yes.
Do you take into account that, a lot of legislatures have EAP programs through their primary employment outside of the legislature? And is that something that we should take into account in budgeting this program?
My stance on that question is that I want to be able to provide resources to folks who are in need of resources. And I think that the cost allocation formula speaks to kind of the financial commitment. I would never steer anybody away from resources they may already have, but I also know that we have a robust resource program for state employees and folks who contract and their family members.
Follow up? Yeah, so is this rate the same as for full-time employees of the company, of the state, I mean?
Yes.
Thank you.
Is there another amendment that you know of floating around on this? I'm curious if we have a couple other provisions. One, can a legislator opt out so that they aren't included in the aggregate cost to the speaker's office? And is there a way to get the legislator to contribute to their own benefit, much like they do on the dental program? Is there an amendment floating around that I just don't know about?
Chairman Edwards, there was a discussion when the bill was before the policy committee in legislative administration. It didn't actually materialize in an amendment, but what they did clarify from their discussions were to suggest an amendment to include household members so that it actually would be in the language of the bill itself was one of the provisions. And another issue that they had discussed was to identify specifically that legislators were not employees for purposes or to be construed as employees for purposes of this act. There was a conversation in front of with the policy committee regarding exactly what you're discussing, which is the current provision for a dental benefit, which a legislator can on their own seek and pay out of pocket for those benefits. Given the current model that we have for the Employee Assistance Program, which is based upon the total number of employees from a specific state agency that participates in it, that if we went to a different type of model like a individual pay model, it would lack parity with the other provisions that we already have out there, and it could run contrary to the funding necessary to actually achieve the good works that they do at the EAP if you change the funding model from that which has already been in place for many, many years as it relates to our memorandum of agreements and with various state agencies. I was going to ask Mr. Lawless if he thinks he could condense it down to less words, but I think that that's hopefully a response to your ultimate question.
So summary is there's not an amendment that came from all those discussions, but there were a lot of discussions in that area. And because we're on the, well, I'm going to come to you in a second. Do we have an amendment on the timeline that I had asked for? Can we go ahead and hand that out and make sure people are aware of it? And then I saw Representative Hull first, and then I'll go to Representative Weiler.
Thank you, Mr. Williams, for the discussion. The current dental employment benefit that is available to the legislature, and in the past when I was a rep, I took advantage of that. We paid for that benefit out of pocket. And my understanding of COBRA laws allowed for that to continue as well. One, if this benefit is created and an employee leaves, right, a legislature chooses not to file to run for re-election or chooses to, right, or does not win an elected seat, what happens? Is this now part of COBRA?
I don't think COBRA is applicable to what you do in the EAP, is it? Because you're not insurance.
We're not in insurance.
So we're cobbling together a response to that. So because it's not an insurance product, it doesn't fall under COBRA. It is obviously a benefit that is provided to state employees, but it doesn't fall under the category of insurance.
Follow up? So if an employee left today, right, a non-legislative employee left today, this benefit would stop upon their departure?
The short answer is yes. One of the issues that was discussed at the policy committee level was to insert in front of the word members of the general court, the word current. So it'd be very clear that we were talking about current members and not either past members or ones who might have resigned or moved out of their particular district and had to resign. So the suggestion was to add the word current to make that very clear. Good question, Representative Hall.
Okay.
Thank you.
Second. So if this is a benefit that is available to all 400, some members are taking advantage, some members are not. Is that equitable to all members of the House?
And Chairman Edwards, if I'd like to respond to that.
Go ahead.
So in terms of the numbers, it is actually not just 400 for the representatives, there's also the other 24 in the other
24.
bodies, so include also state senators and also members of their household. So the current model that we have working with the other state agencies is based upon an understanding that the state agency themselves pay for a proportion of those costs for the services that Mr. Lawless and his employee assistance program provide. In terms of mechanics, 50% is paid for by the department to support his program, which is budgeted through this division. And then the other 50% is from the other agencies, transfers that we receive based upon those memorandum of agreements that have been entered into individually. In terms of the equity, the way that the EAP works, Employee Assistance Program, it's available to all employees. Life circumstances randomly happen to folks, whether it could be substance use matters, if it's issues involving better management of money, debtor creditor, behavioral health, also just all healthcare, including behavioral health, that we would make sure that they would be served. And the fact that somebody wouldn't avail themselves of that, I would not think that that would necessarily be an equity argument. It would just be a personal choice or not wanting to engage or not having to engage. But most people do have life's struggles at some point in time. Mr. Lawless, did you also have a response at all to that?
No, other than just to add that the resources and the support, I appreciate you bringing in the medical piece, because the challenges that can impact any individual state employee, family member, I mean, we hear about it, we see it every day. Anything that can impact one person is also available to any one of us. And so I think to that point, just knowing that there are resources available, you know, in terms of that return on investment, there's a lot of evidence around the benefit of EAPs, and when you bring it into the family realm, I think that's just another added layer around what we all can carry when either we are struggling with something or somebody that's close to us is struggling with something.
Thank you.
Representative Weiler?
You know, for many years, we've been strong on the point that we are not employees in the legislature. We are elected by people. We are not appointed by anyone within government. We can't be fired by anyone within government. We're fired by the people who elected us. So to try to get into employee benefits, I'm opposed. And I think that's why it probably was defeated in the committee. As you say, we've been able to get into some programs where we pay for them, and some people have got into the health insurance, but that's kind of a privilege that's been added, and you pay for it yourself. So this, I see the model should be repeated the same way here, rather than having everybody paid for it, whether they want it or not. We're not employees, I want to say, and so we shouldn't be in employee assistance programs. Thank you.
So you don't have to answer that. That's a legislative policy issue that's outside the department's purview. But Representative Hull?
Thank you. This question's for you. I'm looking at the amendment. This may, yes. This, it looks like the date might have a typo.
Should I introduce my amendment before you ask me questions about it?
Sure, I'll let you introduce your amendment.
Okay, so Mr. Ripple passed out my amendment to this bill that the effective date is not a typo. It's July 1, 2034. So that's basically 10 years. What's the rationale? The rationale builds off of what Representative Weiler said, is that this is a new benefit. This is, there are no questions for you in here. So, it builds off the idea that as legislators, we're not signing up for a compensation and benefits plan like an employee. And this is a new benefit. And because it's a new benefit, I would want to separate from the current vote, though that population that would actually benefit from the benefit that we would be creating with this bill. And so I just arbitrarily said 10 years because I don't know how many of us think that we're going to stick around for 10 years so that we can get access to the employee assistance program. We'd have to be a little, I'm not going to say the word nuts maybe, but go ahead.
Thank you for your explanation. I was going to ask whether that could have been July 1st, 2025, which is the beginning of a new biennium financially. I thought it was a typo. That's how I took it. But at a
But-
minimum, it should be the beginning of the next budget cycle so that no one that I understand your logic and I completely support your logic. No one who is a direct beneficiary of the program would be voting on the program. And there's a congressional level constitutional amendment type thing as well that talks to this, that we should not be voting on things that directly affect us. So at a minimum, even if there's a separate amendment, I would request that it not be any sooner than July 1st, 2025.
So if we go down that road, I'm totally open to discussing what the end date is. I just want to make sure that there's a clear boundary between the people who are voting to self-aggrandize their benefits package from the ones that actually receive it. And I want it separated, you say by budget year, rather than say budget cycle, I would say election cycle. Because the voters should determine whether or not we should be getting this additional benefit, not ourselves.
We're in agreement. Thank you.
Okay. Representative Tversky?
Thank you. I would just like to say that I can support the logic for 2025, since all of us don't know if we're going to be here next year. And I think that, we don't know who those 424 people are, but I believe that the program itself is invaluable to those who find themselves in a situation of having to need that. And I think it could help in terms of retention of quality legislators, allowing them to maybe get, a referral somewhere, just a listening ear to help them show up and do their work, support themselves in a way that allows them to serve, allows them to show up. And I, at first, also, with my colleague over there, thought it was a typo, but I think that by adjusting it to 2025, we may be in a position that we could satisfy everyone's needs to push it out.
All right. Yes. So the other concerns I had about this, I heard everything you said. Everything you said is reasonable. The free market has validated EAPs as being a worthwhile employee investment. So I don't have an argument on that level. My argument against this bill is that it's a new benefit for legislators. And as Representative Weiler pointed out, and as I've come to understand it, is that we have assiduously held to the idea that the compensation we get per the Constitution is pretty much everything we get. I mean, we get mileage, that's not in the Constitution, I don't think, but adding benefits for legislators is just a really bad precedent. I don't want to break glass on that. I don't want to do that. And then the fact that this is the first cost-free benefit that would go to legislators. We can sign up for the dental program, we can sign up for the medical program, but this would be at no cost to a legislator. And that's another precedent that I would want to avoid. The fact that this program doesn't have an opt-out procedure built into it, and that it's including all family members. And so there's a kind of a redundancy here because some people have full-time benefits. I think Representative Stringham alluded to that, so there's kind of a double dipping or double benefit component to this. So those are reasons that I have a problem with this bill. I just wanted to get that out there. And go ahead.
Well, I'll say first off, I don't have a benefit since I don't have a full-time employer. But I'm just curious, when you were talking about we don't have a benefit like that, the first thing that popped into my head was the complex nurse, the state house nurse. you know, we have that opportunity to go and meet with the nurse if we're having, I would say I'd be welcome in there for a physical issue, but also, you know, a mental health issue. I need a little guidance on something. So I guess I would argue that we do have a benefit like that related to our well-being already.
I think that's an excellent possible example. I'd want to drill into it just a little bit more. It was my understanding that the nurse on site is really here for emergency care in case somebody, the day of session or the day of committee, needed some kind of medical assistance. I have not in 4 terms perceived the nurse as somebody I could go to almost on a clinical appointment basis to get, supplemental help other than emergent care. So that's just a fact thing that I don't know. Do you know?
My first term, I had 2 different surgeries. And so I connected with her often on my well-being and my ability to serve, and getting a better parking spot, getting some over-the-counter medications when I needed it, when I was in committee, different things like that. And I just, I see that as a benefit of working in the building. And I guess I'm just using that as an example that we already have that.
Did you have a question? So you haven't asked one yet, so go ahead.
Thank you, Mr. Chairman. My question is, I had worked when I was on that cusp between being a contractor and an employee, and that line was very nimble on the federal government's definitions about when they decided that you wanted to be considered an employee, even though you were not really acting as an employee. I'm concerned about what the cost would be to the state if doing this would move us towards a path of being deemed employees and therefore subject to things like minimum wage and other benefits.
Could you elaborate on that? Are you concerned that the presence of one employee-like benefit could trigger an interpretation by a future court that we are in fact employees and therefore become unintentionally subject to the minimum wage law?
Yes, especially if other benefits also follow.
Representative Stringham.
I just want to comment again from my own experience a little bit differently that, we offer health insurance. Employees all pay a portion of their health insurance. We offer retirement. Employees contribute to their retirement programs. We offer dental. Employees pay a portion of the dental. We have an EAP program. Employees don't pay anything for that. I get your point of slippery slope. I do think an assistant program is about having, a body of people getting work done that when they need some kind of psychosocial place, they have at least a place to start. The EAP program runs out pretty quickly. If somebody has, a major mental type of issue, then it has to go back into more traditional health insurance or out-of-pocket payment. So I don't, while I appreciate the enlightenment about this kind of being an employee-like benefit, I don't view it as an employee benefit. I view it, this is something that, the body that's trying to get work done is doing so that they have as capable a group ready to move forward as possible, especially under these types of circumstances. Thank you.
May I ask you a question? In an employee handbook, in the fields that you've been in, where an employee assistance program is offered, when the employee receives something from HR saying, here's your compensation and benefit package, are EAPs listed as a benefit as part of an overall benefit package? In my experience, they have, but I've only been in 3 different corporations that had EAPs.
I appreciate the question. I don't remember if it's in the employee manual or not. So.
Mr. Williams, so none of that was for you, but I'm just curious, as an attorney, or do you feel like you're in the right area to comment on Representative Leon's observation on employees. That's a special section of law that you may not be familiar with to the extent you're comfortable saying something.
Chairman Edwards, thank you. I am here today in my capacity as the legislative director. I am an active member of the New Hampshire Bar. My commentary is the same observation that was raised by Representative Leon was also raised at the policy committee before legislative administration. One of the potential remedies to that is to put language like this into the bill, which would be nothing in this section shall be construed that members of the general court or employees are otherwise deemed anything but members of the legislative branch. That was one of the alternatives that was somewhat discussed before that committee. And I know that that's not getting to the complete substance, but certainly if you need additional information, you have the wonderful attorney Jim Seanti, who could be available to you to address any other further questions where he does represent the legislature.
Do either of you have anything else to add based on observing our conversation? And do any legislators have any questions to ask further? Representative Mooney, think about what you may want to still say.
Thank you. How many currently full-time state employees have access to the Employee Assistance Program?
Yeah, so the estimates are over 10,000 of full-time state employees. When this is initially budgeted, it's anticipated how many positions may be filled, and then there's always kind of transitionary states with positions, but it's over 10,000 at this point.
And part-time?
I don't have that number, and that may be represented in that total number. I apologize. I don't have it separated that way.
Thank you. Full-time, I'm guessing, is 35 hours,
Most employees,
37?
37 and a half. I
Okay.
shouldn't say most, but there are 40-hour employees depending on some of the institutions.
Part-time is approximately 20 or so?
I'm not sure.
Okay, I guess my question then becomes, if this bill were to pass, legislators would be, for lack of a better phrase, the least working class of individuals to access this program, considering some don't have committee assignments off for the summer, campaigning in the fall, and so on and so forth. Is that an accurate statement?
What I would say to that is I know we provide services to seasonal employees, and there's many departments that contract us that have a different kind of range of what hours their employees may work, so I wouldn't be able to say more than that.
So I think you're bringing up an excellent point. We are the smallest part of the part-time employee force technically. And so could you get to us a copy of the policy that says, part-time, this is whether or not you're eligible, whether it's seasonal or whatever. I just want to be able to benchmark what the legislature is relative to the part-time employees that receive this benefit.
We don't distinguish between part-time and full-time in terms of our service delivery model. If you are,
No, not service delivery, but eligibility.
anybody would be eligible.
If
the
an
services.
employee is working 5 hours a week, I don't know that we have any of those, but they would be eligible for the EAP program?
If they had paid based on that cost allocation formula, then they would be eligible for the same services.
Mr. White?
Good afternoon, members of the committee. Nathan White, Chief Financial Officer with Health and Human Services. So I just kind of want to level set just to help address this question. So this coming August and every other August during the agency budget phase, we work with EAP to develop their budget. So for the current fiscal year, $928,000. We also, during that point in time, we work with the Department of Administrative Services to identify what are all of the funded, classified, and unclassified positions that currently exist. For the current budget, it was almost 11,000. We take that, we apply a ratio, and then we divvy it up. And so when you look at our budget, when we work with Division 3, a percentage of that, roughly half, is other funds, the money coming from the other state agencies, and then the remaining amount is federal and general funds for HHS's budget. So we do not budget down to the part-time employee level when we're making these decisions. So if this bill were to pass, the 424 additional members would basically be factored into that roughly 11,000, which would represent, I don't know, like 4%, something like that off the back, just back of the envelope math. So that would be that roughly $17,000 annual impact, where we would assume we would receive roughly $17,000 from the legislature to pay for that, to provide those services.
Okay, so that was good. That's all money, right? It isn't specifically eligibility, but I think it's safe to assume that part of the eligibility answer is they have to be hired and they can't be no longer an employee. They have to be actively employed. And as long as they were employed enough to show up in one of those classification levels, then there was probably a cost allocation done and the money has been taken care of. And the implication is that they have eligibility.
Yes, and the budget is based on total funded positions, not total filled positions.
Funded, okay. Okay, Representative Leon?
Thank you, Mr. Chairman. When seasonal employees were mentioned, I was curious as to whether seasonal employees, if they come back every season, are provided this benefit when they're not working, just as legislators who are in the off season and not coming in. Do you know if those seasonal employees that are hired every year receive this benefit when they're not actually working for the state and putting in any hours?
I don't have that information in front of me. I think that taking that question as a case-by-case model, if somebody reached out and said that they were an employee, a seasonal employee, we wouldn't be saying, but are you currently working? We would still provide the same services if they reached out.
Thank you.
Representative Hull?
We covered the number of employees that are eligible. Do you have any data relative to the usage of this service? Number of phone calls, right, by month, by however you'd have the data?
So again, I'll reference our data management system because, you know, in the close to 40 years that the program has been in place, a lot of our data has been kind of paper and pencil, Excel, and trying to really identify what a client contact constitutes. Is it covers a lot of ground in certain ways. And so what I will say is, looking at our most research suggests that EAPs operate at about a 6% utilization. We exceed at least 10%. And the reason why I'm a bit vague with that is because when we look at actual numbers of clients served in terms of direct meetings, face-to-face or telephonic, opening a case and providing specific resources, the most recent information I've seen is over 700 looking at the calendar year, which is actually an uptick related to, in part, the events at New Hampshire Hospital. But when we really kind of open that up even further in terms of the data management system providing us real updates around service delivery and trends, one of the things that number doesn't take into account is the fact that we do a number of different groups. We do orientations, we do trainings, we do conflict resolutions within agencies. And so to look at what is counted as a case, what is counted as a client contact, those numbers exceed even the numbers that I've greatly exceed those numbers that I referenced.
Is it possible for you to get us that data just at some level, in some format?
Yes.
Thank you.
Are there other questions from the legislators? That triggered an interesting thought. If you step in to help with conflict resolution, we could keep you pretty busy.
Well, I thought of that earlier, but I didn't want to assume too much there. But we certainly are available in
All
that
right.
way.
So what I'm going to do with this is I'm going to go ahead and recess HB 1363 on the possibility that we can come back, the last thing we do today, to determine what we want to do with it. If we want to exec it late today, or if we want to carry it over to next week, we can talk about that after we recess, all right? All right, so I'm going to put HB 1363 into the recess mode. Thank you. And with that, I'm going to bring forward 1282 relative to the duration of child support. Is there anyone here that's meant to speak on 1282? Any additional words? We did hear it last week, but if there's anyone that wanted another shot or another bite at the apple, this is the time to do it. Anyone in the audience? Public comment, kind of? If you feel like you need more space or more mics, we got the mics at the end of the table, but. Hi, go ahead and introduce yourselves for the record.
Sure. My name is David Wieters. I'm the Information Services Director for the Health and Human Services Department.
I'm Susan Brisson. I'm the Chief Staff Attorney for the Office of Child Support.
And good afternoon. My name is Lisa Dekatowski, and I am the Bureau Chief with the Bureau of Child Support Services with the Department of Health and Human Services.
All right, go ahead and tell us what you want to tell us.
Okay, last week you indicated a number of questions surrounding the IT solutions. I just wanted to address those today.
And just so you know, we did that systemically. We said all of these bills before us have like an IT component. Go take a look at the totality, coordinate the totality, and come back to us to tell us the implications on cost and implementation timing. I think that's what that was, right?
That is correct. Thank you. I do have a handout. However, it's not hole punched if you want that handout.
Oh, no.
My apologies for the lack of hole punches. So the handout actually goes through a number of bills, as you indicated, Chairman. In particular for HB 1282, we looked at this solution, and in order to implement these changes, we need to amend the existing contract with our vendor to support the child support system. That process takes about 6 months to do amendments, working with our federal partners as well as our state procurement practices. And then following that 6 months, we would need an additional 6 months for implementation of these changes. So with that, if the effective date would be that we could be able to meet the requirements of this bill would be a July 1st, 2025, in which point we would be able to go live with those changes to support this bill. In response to the question as to whether or not we have the projects related to this bill resourced and prioritized in our project management system, assuming the bill passage, the department would submit it through our PMO process and identify the resources needed to move this forward.
What's your confidence level? You just said 6 months plus 6 months. Do you need an extra cushion of time in there, or are you highly confident?
We think we're okay. We're highly confident that we'd be able to achieve these changes in that timeline.
Okay. Did you have a revised cost estimate?
No, the cost estimate that's in the
It's the
fiscal
same.
note is the same.
Okay. So it would just slide the spending, maybe. Okay. Are there any questions about 1282? The only financial impact on this was the IT implementation. I'm not seeing any. So I'll give it another minute for people to look at it. Representative Tulerski?
I just have a question, and I apologize that I wasn't here last week, and I caught a little bit of it. This list of that you have here that you reviewed, and I apologize again if this has been stated. Is the fiscal note on this? Is it the changes that are going to have to be done to the technology side? Is it the same cost for all of them? In other words, it's not an individual cost on each bill. You're going to have a larger package to revise your software.
That is a good question. In the case of these systems, they're individual. So each bill impacts different systems within the department. We have a little over 200 application systems that we support. In the case of this bill, it's the New England Child Support Enforcement System that is impacted. And so other bills will impact impact other systems. So this is an individual bill cost.
Okay, sorry, follow up. Was just comparing this one to, now I gotta find the right one. And it had an identical fiscal note in terms of the numbers, so I was wondering if it was that amount to revise the system for both. But that's okay, maybe I was looking at the wrong thing. But you answered my question.
The, I think that was a good observation. There were, Mr. Weeder said, most of these bills are touching different IT systems, but there were two bills that were touching the same system, this particular system, and I think the cost estimates were the same. But we should keep them independent as each bill tries to go through the system. I just wanted to make sure that the department had an opportunity to take a look at the whole impact if they had to do all of the IT systems, because their scarcest resources really isn't the money. It's making sure that they have the trained project management people and the team ready to go. So good question. I don't have any more questions on 1282. Does anyone have questions on 1282? Representative Mooney?
Thank you, Mr. Chair. We did discuss amending the effective date.
What?
We did last time discuss amending the effective date.
So yes, is there a question there? I don't think, I think if we decide we want to go forward, it probably needs an amendment, right?
Correct. I didn't know if you were gearing up to make a move right now, but
I'd like to get through the 3 child support ones and then maybe loop back around to see if we have thoughts on execing each bill, because we have to probably exec each bill. But I want to go through the 3 just to make sure we know where we're at. Any other questions? Okay, so do you want to just drop down to 1595, which I think is the other one operating on the same IT system? 1595, I think, if I'm wrong.
Sure.
I could be wrong.
1595 is on the same child support enforcement system. We call it Nexus for short. So if you ever hear the acronym Nexus, it does stand for New England Child Support Enforcement System. 1595 and 1564 have the exact same fiscal impact into the system. And depending on if they both move forward, we would have some conflicts. However, if they were merged together, we would have a single cost of the $290,000. And when it comes to effective date, it follows the same challenges that we have with the previous bill, where we would need to amend the existing contract for services to accommodate those changes, which would have a ability for the department to implement with an effective date of July 1st, 2025. To address the same question of the previous bill, we do have confidence that if we had the 2 bills move forward, we would have the resources to be able to move both solutions forward.
All right. For the, go ahead, Representative Wallner.
My question is really for child enforcement, not for the technical. So my question is, I just heard the word merge them together. And I'm wondering, are they compatible? Can they be merged together? If you merge them together, what does that mean then? Because that seems like, again, that seems like a policy issue of merging them together.
Thank you for your question. It definitely a policy issue. I think there are parts of them that can be merged together, but then other parts that definitely conflict. So if
Conflict or just they're not aligned with each other? Do they actually conflict and fight each other, or do they match up except where they don't?
No, I would say that they conflict in that there are certain circumstances, described circumstances for child support that are different in one bill than in the other.
Thanks for that. And so 1595 has an amendment, the Bickford Amendment, 2024-1014. Representative Bickford, would you sit over here and grab a mic over on the side? No, you don't have to get up, ma'am. If you want to get more notes to shoot at us, that's okay. Have you, I'm sorry, I'm so bad with names, ma'am. Have you seen Representative Bickford's amendment? 1014 is how it ends. And so because you pointed out a potential conflict, I will come back to you after you've had a chance to think about it and see if that, in your mind, resolves the potential conflicts that we might have between these two bills. All right. Representative Bickford, what would you like to tell us about your amendment, sir?
What the amendment does is pick up the self-support closer. What it does is picks up the self-support reserve from 1564, and it puts in a domestic violence clause in there that 1564 also has. But what we need to do is decide on which child support formula we're going to go with. The one 1595 has a formula that's recommended by years of study. We've spent hundreds of thousands of dollars on these studies that I pointed out to you the last time, which has what they call a 1.5 multiplier in it. The one in 1564 is a simple cross credit, and it only works when you have the exact same income and the exact same parenting time. After that, you'll find the lower earner will start moving away from having an even with the other party. So it does damage the lower earner. The one in the cross, it's called cross credit, and it's a simple thing, but it's not recommended by all the studies that we have. The one we
So sticking on the amendment, it's lines 17 through 20. What was the purpose for this? What are we trying to do with those lines?
Well, you had spoke about having one bill, going forward with one bill, and this would do it, but you would not be going forward with 1564 anymore.
Okay, so this would allow 1595 to carry the load.
Exactly.
Okay. Does the department concur with that?
I would say that it definitely includes things from 1564 that it did not before. I'm loath to say it completely deals with it with the prime sponsor in the room. I mean, she might have a different opinion, but.
All right. So we can bring you back on this. We can either recess it for later today, or if you think you guys need some time to continue to resolve it, we're going to have another work session next week where I hope it concludes in an exec session. So any sort of disputes between the two, we should be prepared to handle. I want to ask the chair. Did you want to comment on either of these, Representative Kitab? It was that a no? You do not? If you may, sure.
Okay.
Good morning. For the record, I'm Caitlin Kutab. Thank you for hearing me. So basically, the special committee on the family court heard a lot of testimony from parents that there's long been a child support issue in New Hampshire. And I looked back and we've had over a dozen bills come through, and every year we'll get something through the House and it gets to the Senate and it gets ITL'd. So, knowing that parents really needed something, I brought together all the stakeholders over the summer. We had New Hampshire Association of Justice, we had New Hampshire Legal Aid, several family court attorneys, mediators. We got everybody together to come up with something that would work. We also ran this by a few of the judges just to make sure that we're putting in something where we're not going to break the 80% that are agreeing, that are going through mediation, but in trying to correct it for the 20% who aren't agreeing. And this was the bill that we came up with, and it fixes three of the big issues that have kind of come out, which one of them was increasing the self-support reserve from 115% to 130%. And then it allows for the parties to share the cost of childcare, healthcare, and extracurricular activities that are agreed upon. And then it allows for some rebuttable presumptions of deviations to the child support calculator based on shared parenting time. And it was really one of the big sticking points. And if you kind of look back, this bill came out of committee 13-0 versus 1595 came out of committee 7-6. We couldn't get agreement on changing a whole calculator solely just based on parenting time, because then you were going to have parents arguing hour for hour about how much time they're spending with each kiddo. And so that was kind of one of the big sticking points from New Hampshire Legal Aid and the Domestic Violence Coalition. They wanted it to truly be in the best interests of the child. And so this was the compromise that we came up with. And I really think, it has, I think it'll be good for the families in the state of New Hampshire.
All right. So when you say this is the compromise,
1564 is the compromise.
1564 is the compromise.
Correct.
And so am I hearing you right that your recommendation from your committee, from a policy perspective, is that we ought to be passing 1564 and not either 1282 or 1595?
So 1282 deals with something entirely different. It's okay to pass. 1282 is completely different.
Okay, so the conflict is between 64 and 95.
Correct.
Okay, all right. Representative Wallner, you had a question?
Well, I guess my question is now to both, but I was wondering, when Representative Bickford was here and he has an amendment, is this an amendment that the Children and Family Law Committee has seen and support? Or is this an amendment from the sponsor?
No.
No to which?
Well, no, it does. Well, I don't know about support because they've seen it in 50, it's just taking stuff out of 1564 and putting this. So I guess yes, the answer is yes, it has seen it. And I would have to say yes, it does approve it. What's in the amendment?
Okay. And do the members of, or at least a portion of the members of the Children and Family Law Committee know that you're bringing forth this amendment to finance? Because it's a policy, and I am
No.
concerned. No. Okay.
We have not met since I came here last,
Okay. Thank you.
and I heard about having one bill. So this will achieve a one bill thing. I mean, the problem is she'd bring forward one bill with a calculator or a formula in it. And I challenge that and say that those people did not utilize this, which we paid $114,000 to tell us what, to give us a direction to go in. And not only did this one do it, we paid $140,000 for this one 4 years before that in the 19. And it says the same thing. And then the Family Law Task Force in 2004 told us to do that and gave us recommendations. Same thing in 2009. I mean, it just goes back and back for over 20 years, telling us that this formula that I'm bringing forward to you is the one we should be adopting. I understand.
Representative Tulersky?
Thank you. Would like to just direct a question to the experts here at the center of the table, if I may. When I was preparing for today, I did have a couple conversations with members of Children and Family Law to try to understand, since we are not the policy committee on this. And someone said very simply to me that 1564 is, they described it as the collaborative, all the parties coming together to work on it, and said that it's a small step. The changes are more moderate, but there was a lot of agreement about it. Whereas they said 1595 was like overturning the apple cart. It was like a huge 180 from where the process is now. Would that be a correct assessment?
I would say, you want me to answer that?
No, I was
No, I
asking
think
the,
it-
Oh,
the
I
experts at the table.
I don't know if DHHS wants to answer your question as worded.
Okay,
Do
yes.
you want to reword your
Sure.
question?
I'm trying to understand which one is a more significant change to current practice, and which one might be a step in trying to fix the problems we have. Which one, it seems to me from what I'm hearing, one is a very large shift from where we are now, and one is a little bit more of a moderate step.
I would say that 1564 is definitely a simpler change.
Mhm.
It's leaving in place most of what we do now and only changes it in certain shared parenting circumstances. But it doesn't give any guidance in other circumstances, whereas 1595 deals with all the circumstances.
That answers my question.
So
Thank you.
I think for the record, I should have probably gone ahead and opened 1282,
I apologize.
1564, and 1595. We kind of talked about them all, which is good. We are a work session, so we're working. Representative Hull.
Thank you, Mr. Chair. In my pile of handouts was a document comparing some of these with specific information in various columns, but unfortunately, no one told me who turned that in. Do we know, does anybody remember this document here? Who submitted that as testimony?
that young lady over there.
Came from the National Parents Org.
Thank you.
You had your hand up first. Was that the same answer? You prepared the document. Okay, thank you.
I'd like to, if I may, answer.
Go
the
ahead,
question also
Representative.
for
Go ahead.
Representative Tulerski. Yes, they're absolutely right. This is 1595 is a much more comprehensive bill that covers child support. One of the other problems with 1564 is it's very likely to drive the deviations up. And the reason for these reports that we are required to have is to find out where the deviations are. And if our deviations get too high, which they're very high now, when the guidelines doesn't work anymore for you, say you do a shared parenting situation, the guidelines we have now are just for a one-parent situation. So, I think 41 states have changed in recognizing shared parenting, and 21 states, I think, are doing this style. It's in the report. And we have, this is very closely aligned with California and Oregon. Now I forget what I was saying. Oh, deviation. Deviation is, yes, when the guidelines just don't work for it, they try to come up with something different. The Supreme Court came down on the judges and said, you can't be doing that, these cross credits anymore. And so that's why we're here, to come up with a formula. And like I say, there are formulas out there that are in the system. And this is a very popular one right here. Does that help? I'll bet Attorney Brisson can answer it better than I can.
I think you were the primary recipient of that answer, Representative Tulerski.
But if our deviations get too high, they can come back, as I understand, and tell us, you're going to have to make some changes. So if we're just doing very simplistic changes, and they're going to be dependent upon the deviations, it's a good chance they'll come back and say, you're out of compliance.
May I respond to that? So in speaking with several of the judges, there would be no issue with 1564. They'd be able to do it just fine. I think, one of the big concerns that came out is that we are not California or Oregon. We do not have the types of welfare programs that those states have to support daycare subsidies and various subsidies that those other states have. And so there is concerns when you're reducing just across the board, making such a big change like this, that families aren't going to be able to afford the needs of their children. And we have to remember that the children are the ultimate piece here that we need to focus on. And so that's why there was a lot of pushback. And that's why each time it gets over to the other side of the wall, it's been killed. We need to come up with kind of a more moderate approach to it. And then if there's more that needs to be done, then we work at it a little bit more. But to go from, one way to completely flipping it around, it does cause for some concern. But in terms of the deviations, it would be right now, they're not allowed to deviate because that's what the statute says. But this would be allowing them to deviate. So it would fix the problem and there wouldn't be a problem with it.
Are there any other comments from the floor? Anyone in the audience? Would you like to come up? We haven't heard from you yet.
Could you?
Could I give you a couple seconds on
Yes, ma'am.
deviations?
Yep.
Every time you do a child support order at court, you're required to do what's called a child support guidelines worksheet, which fills out basic facts of the case and leads ultimately to the math, the calculation of what the child support is supposed to be. That number is, the guidelines worksheet is provided to the court and is eventually will be attached to the file. So the court knows what that number is. If the court chooses to pick a different number for whatever reason, that's a deviation. And those are the type of things that are tracked.
That was helpful to me. Thank you. Do you want to introduce yourself for the record and tell us what you want to say?
Sure. My name is Rebecca Hutchins. I'm a mom of two from Dover. I was part of the working group for 1595. We've spent a long time really reviewing the research, and it's, I understand that you may have gotten my testimony from yesterday. I also sent in this chart that kind of walks through each of the major areas. I hear what Caitlin, Representative Kutab, is saying, and the issue is that the working group from 1564 did not include parents. It included a lot of litigators who go to court and try this all the time. I've been back and forth to court in the last 5 years to change my child support order 6 times because we don't have a tool that works for families that have shared parenting. We continue to fight because it costs the same amount of money in 2 houses. It costs more than what the child support calculator that we currently have shows. So all of the funds, I pay my ex, I still also pay all of the extras. I still care for my kids half of the time. When we start talking about social services and what needs to happen because people are going to be getting less money, what about the families that have been overpaying for over 20 years when this research has been out telling us that we need to change this? There's no arrears that I will receive. None of that will get rectified. And all it does is cause more fighting between families. We were not included in 1564. I have reached out to the NHLA. I've reached out to the New Hampshire Association for Justice. My calls were not, I did speak with Mary Kruger in depth about the issues. The domestic violence issue that we've spoken of in conversation, it seems that there are only 4 cases that it would actually affect currently with the NHLA. There's been conversations about coercive control with financial situations. I say it works both ways. The obligor is not the abuser. Sure.
I don't want
Yeah, I don't
to
know.
cause you to end prematurely.
I wish that I could convince you that.
So,
Or-
so
or-
let's back up.
Sure.
So it's your testimony that you think parental involvement should cause us to want to pass 1595, and the lack of parental involvement, does that affect your position on 1564?
1564 only helps a very narrow group of people that already agree to share all costs 50-50. It's the only group that they're working with.
Okay, I just wanted to get your position. So yes or no to 1564? It seems to help some people, if I'm hearing you right.
1564 and 1595 can be combined to create a tool. If 1564 is to pass as is, there's a whole middle section, section 5, that would cause more deviations, which is absolutely against the review, and cause more conflict for families trying to navigate this, myself included.
Okay, thank you. And your last name's Hutchins or Huggins?
Hutchins.
Hutchins. Are there any questions from the panel for Ms. Hutchins?
Oh, I do not.
Question for the chair. Can we get a pink card?
I don't know that our work sessions use pink cards. Mr.
Well, just-
Ripple, do we do that?
Just so we have contact information.
I think we want to know how to get hold of you. So if you could give us your contact information.
Happy to.
All right. But technically, we don't use pink cards for our work sessions, do we?
You don't need them for work sessions, no.
I think the biggest thing that I just want to say is that if both of these pass, which one do you get more bang for your buck? Right? They cost the same amount of money. One helps a tiny group and the other helps everyone, including the family court, which is already 95 helps everyone. The family court's already having trouble. Families are already getting different rulings based on whichever judge you get. This doesn't help. 95 will solve that.
Representative Hull.
Question of the chair. So this falls in Division 3 because it's in the domain of families and healthcare and right, kind of our jurisdiction, but there's a large element of this that Division 1 was considering relative to judges and that. I do have a question, and I'm not sure who the right person to ask this of, whether it's our other division or whether it's someone from the judicial branch. Does either one of these have a lower impact, meaning less need for more judges? My current understanding is we are 17 judges short in New Hampshire as of now.
So you're going to have to refresh my memory because I don't think the fiscal note on these three bills actually put a dollar next to the impact on the judiciary.
I don't think it does, but I do think there is an element of how we change policy relative to the impact on the amount of time in the courtroom. And because of that, and knowing that we have this gaping hole of number of judges, if one of those actually reduces the workload, that's advantageous to the state. And that's the question I'm trying to get to.
Okay, so I can wrap my head around that one. Just between 64 and 95, which one feels to you, Representative Katab, as having a benefit to the workload management of the judiciary? Are they both equivalent on judicial workload or different?
Thank you for the question. So I'm not sure that there would necessarily be much of a judicial impact, although I will say that the mediators did feel like 1564 would help some more parents to be able to come to agreement that are currently in conflict and keep them out of going to court. So about 80% of the parties tend to settle outside of court and 20% of them are more higher conflict and need to get decided in court. So they felt like they'd be able to get some more parties to actually agree. They were concerned with adding the element of arguing over the number of days with each party with 1595 that it was going to create more conflict.
In Representative Bickford, it looks like you have a different opinion.
Yes, I do. In fact, when I had read the $114,000 thing, it says it will be less conflict in there. And you just go to the table. They'll have a table, and they'll have a graph there, and it says, well, this much time, this kind of income, and bang, there it is. And she probably knows more about it than I do.
I think I want to start wrapping this up. Are there other questions from the legislators, from the panel? Any last words of wisdom from people who've come forward? All right. So I'm going to go ahead and recess these three bills. And Representative Wallner, I want to be able to talk to you during the course of the afternoon about whether or not you think we're ready to exec any of these. Okay. All right. Well, thank you very much. That closes those three bills. I would like to, and those three bills are 1282, 1564, 1595. I want to open 1669. Oh, Representative Leishman, you're here now. I didn't see you come in. Okay, because you're here, I'm going to go ahead and open 1573. Now, the reason we're going to 1573 next is because the fiscal note has a fairly dramatic impact on the judicial branch, and Division 1 handles the judiciary. So I wanted to make sure that their point of view is integrated in what we know and what we think. So going to 1573. Okay, so 1573, did we have the Pearson Amendment before us last week? 0980?
We did.
We did? Okay.
There was certainly a lot of room. If I could talk.
Go ahead.
Thank you, Mr. Chair. Yes, that amendment was introduced and discussed last week, though I feel there's a lot of room for further discussion on that, as it wasn't entirely described or really combed through as adequately as I think it could have been.
All right. Go ahead, Representative Wallner.
Well, I just wanted to remind you that this is the one we have the subcommittee on.
Right.
And I think I've called the subcommittee for Wednesday morning at 10. I've reached out to both the department and to the Child Advocate's Office, but also today we also contacted the judicial branch about having a representative there on Wednesday to talk about the fiscal note that's in the bill for the judicial branch.
Okay, so thank you for the trigger there. I do want to say for the public and those that are here that 1573 represents the legislature's attempt to resolve a fairly significant problem that we had with outplacing juveniles out of state because we didn't have the capacity for them. And that it came in with a pretty hefty initial cost estimate. We've asked the department and other stakeholders, to include OCA, to go back to the drawing board to really prioritize where we're getting value, where we're confident that we're improving the system and reducing the risk to our kids, and doing it in a more efficient and less expensive way. Because there's enough moving parts here, we've set up in the division a subcommittee that Representative Wallner has volunteered to head up of three people, Representative Priest, herself, and myself. She's been working with the department. The department has been working hard trying to go around all the stakeholders to figure out, what do we really need to do? So Representative Wallner has us on track to have a subcommittee meeting on Wednesday morning. And we're going to see how much we've learned since last week. And it feels in the informal progress reports I've been getting from Ms. Morris, and you can come on and take a seat because I want to ask you where we're at. My general perception is that the department has been working hard and successfully at coming up with some mutual accommodations of concerns at maybe a lower cost to the state. So that's my introduction for you. You can refute that right away if you want.
No, I would say that we've been working closely with the OCA because we do agree with the general premise of the bill. We agree with the desire to increase our scope and create a more robust program. We just want to make sure we can do it efficiently and effectively within the financial constraints.
So for the record, do you have Ms. Morris's information? Okay, go ahead.
Oh, sorry. So yes, we are working with them. We have shared with them any changes we would recommend, and then we're going to try to work on some financials for you on Wednesday as well.
So because you're changing the overall recommendation of what we do with this bill, it's the case then that the fiscal note still needs to be updated to catch up with where you guys are aiming to be on Wednesday.
Correct.
Okay, so we don't have new fiscal or a new fiscal note today for that we really should consider very hard. Mr. Ripple, you want to say something?
You don't have a new fiscal note. The only thing I have is a spreadsheet provided by the department, but again, not in response to the amendment discussed last week, but rather in response to the bill as amended by the House.
All right, so to the panel, I would suggest, or I'll tell you what I'm going to do, and you can do what you want. I'm not really even going to look at it because I want to wait until the paint has kind of dried on the new look to the bill, and then consider the adequacy of that new proposal, and then we can worry about the money after that. So I think next week, a week from now, we'll bring 1573 back and really be able to bring it back to the whole Division 3 to figure out what we want to do. So would you mind just giving us like the 3 or 4 major highlights of the trend that you're going from what 1573 represented when it came to Division 3 and where you think it may be trending? I don't want you to get out on a branch though.
I can tell you one major change will be the certification process. The recommendation in 1573 as it passed the House was 4 visits per year. We are recommending at least 2, and it will say at a minimum 2. One will be the annual timely, scheduled certification, and then the second one will be unannounced. So a spot check.
Okay, and then because we have Division 1 here, I have to specifically ask, have you had anyone from the judiciary take a look at the new proposal? Is there a new proposal for when they're supposed to get engaged? Is there any impact on the initial fiscal note that was dealing with judicial?
I don't believe there are any major changes to that portion. That would remain the same, but that is something I defer to the OCA on.
The
The office,
OCA,
the child
come on
advocate.
up. Okay, and
You can speak to that better than I can.
and for those who are curious why I point that out, on the fiscal note, the fiscal note suggests that the judicial branch requires 9 new positions, and that's a bunch of new positions. And I know over the past year or 2 or 3, Division 1's been funding a growth in the judicial branch. And Representative Leishman, if you'd like, it would be perfectly great if you joined us at the table so that you feel comfortable asking any questions. Well, if you have, no, I'm just saying if you have questions, I'd like you to be able to use a mic. All right. So would you introduce yourself again and say something that causes Representative Leishman to have questions?
See what I can do. Attorney Alyssa Mascio, I am the Associate Child Advocate for the state of New Hampshire. I think one point of clarification in the new amendment that is coming is that prior amendment was not intended to be a replace all amendment. It was just intended to make some small tweaks. So essentially that section around the judiciary would be the same as what was passed by the House at the end of February. We have looped in Erin Cregan, who is the judicial legislative liaison. I think the conversations we'd like to have with her, and I do hope that she is coming Wednesday morning, is just around the data and the numbers of kids that this new provisions around hearings would touch, that it's a pretty small percentage of the total number of children in placement. So hopefully we would be able to have a more robust conversation about those costs when we're talking very specific data, number of kids, where they are, under which purview they're placed, whether it's 169B, C, D, or a voluntary placement, which doesn't involve the court.
So this may be a little bit of a jump ball question. I know the department has spent a lot of time rethinking how we can make the kind of the clinical oversight role more efficient. Has any effort been done to take a look at streamlining or improving the obligations or the reducing the obligations on the judiciary? And that could be kind of a yes or no first. Has there been an effort to take a look at the judicial workload to see if there's a way to redo the workload so that they need fewer people?
Not between the two of us, no, but that's why we're hoping to loop in Erin Cregan to have some of those conversations.
Okay, so Representative Holder, you have a comment?
I do. Thank you. During the public hearing on this, there was a discussion about changing the paradigm from routinely forcing the judicial branch to review, I don't remember whether it was every 30 or 60, I think I heard both days, what was going on, to a paradigm where it was a strategy of elevation. If the child care, the caseworker, or somebody else triggered an event, the judicial branch had a certain time to respond. Was that language even looked into since we last were here?
We certainly did discuss that. I think the purpose of this bill overall, as well as the amendment, is both preventative in nature. It was also a response to the judiciary kind of saying they felt they weren't getting enough information, as well as long-term, at least from the Office of Child Advocate standpoint, in line with Director Fleischer's goal to get kids out of residential care. So the purpose of the increased judicial oversight of that small subset of children was really to help move them more quickly out of residential care, both helping the child and reducing the cost to the state for paying for that. So it didn't really align with an idea of just waiting till there's a problem and elevating it, because the idea is to get the kid out of residential care more swiftly.
Follow up. So I understand that, and I can see why triggering the judge and getting the judicial branch to review this, but by no means are they going to be experts in the world of child care, of treatment, right? That expertise is in the Office of Child Advocate, is in DCYF, right? Is the caseworkers are going to have far more expertise about this than the judicial branch. So having the independent review of the judicial branch, I don't know that gets us to that solution. I do think that if there is a problem and we need a court order to address that quickly, that trigger mechanism has real value. If I believe we heard testimony about someone being restrained inappropriately, if that's going on, having a means to elevate that quickly, even through some sort of ex parte court order service, would be beneficial. And I don't know that the amendment that's been proposed addresses that.
I appreciate the question. This amendment does not address that. that mechanism already exists. I've practiced both as a parent attorney and as a DCYF attorney in the system. A motion can be filed at any time by any of the parties in order to get judicial oversight if there is an urgent issue. I think some of the question you're asking is actually addressed in HB 585, which was a retained bill that the House passed in January, and is reflected also in SB 463, which gives attorneys to children in residential placement, which would be, frankly, the person who would file that escape clause urgent motion.
What were those two bill numbers? SB 463 and
HB 585, it was retained last session and was passed by the House on January 3rd, whenever you guys had that first floor session.
thank you.
Question for you, Representative Wallner. Did you mention to me that we had somebody here from the judicial branch that was going to talk today, or did I make that up, or did somebody else tell me?
Well, I think I said that we had reached out to someone from the judicial branch to join us on Wednesday. Now, whether that person, I don't know the person when I see them. So if they're here, they might be. But we did let them know that on Wednesday we would be meeting, and I'm hoping that she can be there at that point.
Oh, thanks for the reminder. Okay, so this is what I had in my head, and I'm wondering if I need to reevaluate this. What I was hoping we would be able to do Wednesday is to really understand what the final amendment ought to look like to 1573. Go ahead and get that over to OLS so that we could consider it Monday. I'm wondering if we've done enough homework on looking at the judicial obligations to include them in the one more amendment, or if we still have sort of a separate track that ought to be worked. What are your thoughts on that?
Well, neither today or the day that we had the public hearing on this, have we heard from the judiciary? So I think I would want to wait and hear from them before I started making any sort of changes or modifying anything.
Right. So right now I'm just thinking about my timeline, which was that we ought to be done with the homework Wednesday morning, but we really haven't even opened the can of worms yet on looking at on the judiciary. So I don't think it's reasonable Wednesday morning to have a potential re-engineering of the judicial obligations in time for OLS to write an amendment for Monday. That's sort of where I'm at. Does that sound rational, that my timeline is, we need to readjust my timeline?
I think we probably need to readjust the timeline.
All right. Okay. So, Representative Leishman, would you like to, I would like to invite a member of Division 1 to come join Representative Wallner's subcommittee Wednesday morning, because we're very good at working with DHHS to relook this stuff. But you know, if there's something in here that Division 1 needs reworking because of the financial impact, then I think we need to get you engaged with us. All right, so for the folks at home, Division 1 Chairman Peter Leishman said that they're busy Wednesday morning, but they're going to try to have representation at the subcommittee. All right, so thank you for what you guys are doing. Do you have any final words now that we've kicked over some rocks, and we're gonna work harder on it on Wednesday morning, try to come up with something and see how far we can go. Got anything else?
Nope, I think we're good on this end. Thank you.
Okay, anyone in the audience? All right, so I'm going to close 1573. Okay, I am ready to do HB 1669 relative to restricting data sharing through the state immunization registry. Is there anyone in the crowd who's here specifically for 1588, 1598, or 1593, where you would appreciate me doing those first so that you can speak and go? Is there anyone for those three bills? Mr. Weeder, you're going to stick around because there's some IT stuff there when we get to them. Okay. Mr.
Chairman?
Kay? You're here for 1593 if we need you, but you're not here because you have something specific you want to put on the record? So Representative Leon?
Actually, Mr. Chairman, I sent some language to OLS as an amendment to 1669, so I have no problem in dealing with the other bills sooner. I'll let you know when that comes in,
Oh,
if that's helpful.
sure.
Okay, thank you.
Okay. Representative Stringham?
Alex's amendment was sent in along with a change recommended by Mr. White, and it looks like that one was prepared. So there is an amendment that could be reviewed for 1593 if you want to do that.
So let's go ahead and do that. I'm going to open on 1593. It's relatively short amendment, so I'm just going to let everyone read for a minute. This is the shall therefore be referred to as the Stringham Amendment, 1055. So Representative Stringham, would you please summarize what caused this amendment and what you think it does?
Well, I'd ask for some help with Alex. I will say that one of the changes, the last line of paragraph 2, says any unexpended funds shall lapse to the general fund. Used to say July 1st, 2025, and now says June 30th, 2025. Finance felt like if the monies had to be held, that would put it into the next biennium, and moving it up by 1 day, what a difference a day makes actually does make a difference there. In terms of the other wording changes, I'd prefer to have Alex talk to Mr. Katrubis, if you could.
So we're all struggling with your last name. So, Katrubis? So Mr. Katrubis, would you come talk to us?
Special K is what we call him.
Good afternoon, Alex Katrubis, representing the area agencies. So yes, there's 3 changes to this amendment. Representative Stringham, there's mentioned the first one, which was I believe on line 9, which changes July 1st to June 30th. It also, on line 6, we changed it to, in the bill as it came over from Health and Human Services, it said the fiscal year ending on line 6. It said for the fiscal year ending June 30th, 2024. So we changed it to the biennium ending June 30th, 2025. And then really the big change is, those were just technical issues that DHHS had pointed out, and I think they're correct to get those updated, which we've done. The policy, it is kind of a policy change different from what had come over from Health and Human Services, but I think it addresses the chairman's point about why should children with disabilities be treated differently than other individuals who have recreational needs. And so this bill would only apply, this amendment would make the program only apply to adults. And the theory is that children with disabilities who are in school have more opportunities because they're in school or in special education. They would have more recreational opportunities than someone who was an adult. So that is the big change here, that this would only make the program applicable to adults who have either graduated or exited the school system.
Thank you for that. If I could rephrase what I think I said.
Sure.
I just wanted to make sure that what we were doing here, we could take a look, we could talk to New Hampshire tax-paying families that aren't receiving any benefits and be able to explain and articulate to them why this program was fair, that it wasn't, given that it wasn't helping their family directly. And so I think that's what motivated this, is to try to answer the question for New Hampshire tax-paying families. Why this population? Why is this fair and reasonable? Is that?
Yes.
Okay.
And I think the reason would be that, as I tried to explain last week, that these are individuals who, in many cases, are just on Social Security. Maybe they have a very, very part-time job, and they don't have the income, and their families they're getting older. You know, they're in their 70s. Should someone who has a parent in their 70s be responsible for their adult child's recreational needs? So I mean, the bill has really been. There's been a lot of compromises along the way. Originally, it was $1 million appropriation. It's been cut in half. Originally, it was a continually appropriated fund. We were going to stand up rules. Now it's only basically a 1.5-year program that'll expire, and we'll have to start over again in the next biennium. We put a cap of $600. Originally, there was no cap in there. And now we're making it applicable only to adults who've left school. So that we have made a lot of accommodations, understanding that this is obviously an unusual request in the off-budget cycle.
So because this amendment restricts it to adults only, what's your gut tell you about what it does to that 500,000? I'm not.
You might be able to reduce it a little bit. If you give me a little more time, I could try to get some information on age.
How about till next Monday afternoon?
Sure, I will try to get some information about utilization in the past based on age.
Does your instinct tell you that it'll be significantly different than 500,000?
Depends what you mean by significant.
100,000.
I would say probably not more than 100,000.
All right.
Yeah.
Okay. Are there questions for? Go ahead, Representative Leon.
Thank you, Mr. Chairman, and thank you, Mr. Katrubis, for being here with us. I like the way that this amendment is going. Thanks for cleaning up some of the language we had in HHS. When we're looking at this population, are they primarily composed of people who are getting the Social Security and contractually are required to pay for most of their services with that Social Security?
Yes. So exactly. So if you're, I tried to give this example last week. Suppose that you're in a staffed residence run by an area agency or a different vendor who contracts with the state. They give, I think, all but $74 a month of their Social Security goes to room and board, because Medicaid does not cover room and board. So that really goes to their food and their shelter, their Social Security. And as I said, some of them do try to work part-time jobs if they're able to, but and some of them obviously have families that can help, and they're not going to be asking for this. This is really for those situations where they don't have those families that are able to chip in for some of these recreational services. And again, the families throughout their lives really have gone above and beyond, because we know that this population requires a lot of family support, and that's really kind of a backbone of the system. But at some point, those families have a limited ability as the caregivers age to be able to help out. And as I said, if you're in your 30s, your parents are in their 70s, how much longer can they continue to contribute to pay for these things? So that's what this is trying to get at.
Okay. Thank you. And if I can do a follow-up, since this isn't designed to continue into the next budget cycle, would it be reasonable to ask to have information on the utilization, whether they're people who are on Social Security or if they're in any other population, so we can really understand what we're doing, so we can make sure we craft this well when we come back to this next year?
Yes, I mean, again, this is another point I didn't bring up. Originally, I think the department was going to administer this program, and they, if you look at the original fiscal note, they were going to need a part-time staff person. So this requires them to contract it out, and I would be happy to work on some language that would require that contractor to issue a report that the next legislature can review. So we would have some really good data. By separating it out, we're actually it's gonna be a lot easier for me to get you answers on utilization, on age, on what type of services. Because in the past, as you heard, this was all sort of buried into the budgets, and we have to go in by hand. And that's why it's hard for us to get good data on this right now.
Thank you. That'd be very helpful.
Mr. White?
Good afternoon again, members of the committee. Nathan White, Chief Financial Officer. I just want to point out a couple of technical timing issues on utilization. If we go out to bid for this, we'll have to develop an RFP, an RFA, whatever it might be, post it, and then go through the contracting process. So number one is we wouldn't have the utilization figures for the agency budget in August. Number two is by the time that contract goes live, potentially 6 months down the road, and the legislative phase starts, at the House phase, you may only have about 2 months of utilization at that point in time. So there probably won't be a lot of great information going into the state fiscal year 26-27 budget for this purpose.
Thank you. And thank you for that information. Is it possible just to simply administer these through the area agencies that are already providing services for this population?
We would need to sole source those contracts, and if there's legislative language that would help, or those amendments probably more so, if there's legislative language that would help direct us to do that, that's certainly helpful. That way we don't come to GNC and say, this was our sole source request based on our interpretation of what the legislature wants us to do. But if it's in writing, that's certainly a little easier.
Would it be possible to get some sort of language like that? I know I'm just a substitute here, but that seems like it
You're
would be helpful.
so much more.
Thank you.
So you've seen this amendment, the Stringham amendment?
Yes.
Okay. Do you have any issues with the new proposed dates on line 6 and line 9?
No, I think the changes are consistent with the way we typically appropriate funds. So thank
Okay.
you, appreciate it.
So Representative Stringham, there's been some conversation here about maybe an amendment to the amendment. Are you tracking it? Do you think you can work with people to give us one more shot at this for Monday?
Absolutely. And Mr. White, if you could help with sole source language, that would accelerate and help you out. Once the bill's enacted, I would appreciate it.
Are there other questions on, where are we? 1593? Anyone? Anything else you want to say?
The only thing I would say is, my hope is that we'd be able to get under contract maybe in November. And that might give us 5 to 6 months of data, at least maybe towards the end of the House phase. So to the extent sole sourcing would help speed things up. But that was my original thought when we were going to go to contracting, is maybe November 1st, we could get this up and running.
So personally, I hate sole sourcing. I mean, you really need to have a strong justification in my mind for a sole source. And I'm not sure that this meets a threshold for that. But maybe we could talk about that. Okay, so thank you for your work on this, and I know it's been a lot of changes, and I appreciate you sticking with it. So
Thank you.
And thank you, Mr. White. If there's nothing else, I'm going to close 1593. All right, that leaves us down to 2. I'm going to ask, well, 3 actually, because 1669 we're waiting for the amendment to come across the line. So I'm going to turn the gavel over to Representative Mooney, and she's going to chair our work session on 1598.
Thank you, Mr. Chairman. Again, good afternoon to members and to those watching online and in the audience. This opens the work session on House Bill 1598, an act relative to the Department of Health and Human Services management of Social Security payments and veterans benefits for children in foster care. I want to remind the committee first and foremost that this came out with an ought to pass recommendation out of Children and Family Law 12-1, and then on a voice vote through the entire House on February 1st, 2024. The first work session on this bill was last week, and it's a deep bill. There is no doubt about that. A new concept for New Hampshire to adopt. Lots of questions, lots of details, lots of information. Since we last met, various and very specific questions were submitted to DHHS. And I know that legal assistance and also disability rights has worked very heavily on some details that need to be ironed out related to this bill. There's also an individual here whose expertise is on Social Security and its benefits and would also like to weigh in and perhaps take questions with regards to that aspect of it. Is that individual here? Thank you. Okay, to start, we're benefited by the fact that the prime sponsor is here with us, and that is a huge plus when a division in finance is taking on a bill, is to hear it from this prime sponsor, what it does, what needs to be done, and what the recommendation should be. So with that, I'm going to recognize Representative Wallner for any comments you may want to make about your bill, House Bill 1598.
Well, we did have a public hearing last week and I introduced the bill. I guess what I said last week was that several months ago, I was surprised to learn that in New Hampshire, we actually, when children go into the care of the state, either for foster care or residential care, if they have a Social Security benefit, the state actually keeps that benefit while the child is in care. Most of these children, or all of these children, have very serious disabilities. You do not get Social Security as a child unless you have serious disabilities, or their parent has died. And so these are some of our really neediest children, and now they find themselves in foster care or taken from their families into a residential situation. So these are kids that really what ends up basically happening is that they're actually paying for their own foster care. And many states are moving towards changing this policy. And New Hampshire actually, several years ago, had a policy where parents, while children were in foster care or in the care of the state, the parents were billed for the care. And I think 2 or 3 years ago, we changed that policy. So we no longer do charge families while their children are in out-of-home placement. And what I could see is the only group that's really left paying for their own care are the children who have these disability incomes. And it is complicated. I won't gloss over that. I've learned a lot about it from a number of people. And I think that what would really be helpful is if we had the person from Social Security, the person who really has expertise in Social Security, help us understand some of this. Legal assistance has done a lot of work, as has the Disabilities Rights Clinic. And they're all here, I think. And they have posed a series of questions to the department, which we're hoping that the department can come up and answer today. Thank you.
Thank you, Representative Wallner. 5 specific questions I'd like to focus on and hear from everybody. The order is up for debate. So, and I would like this to be a real work session with regards to, we'll take one question at a time, hopefully do this at about half an hour, and then any feedback either from us legislators or those in the audience that have an interest in this bill. So, Representative Wallner has brought to light our expert on Social Security. Would you like to open with any particular comments overviews or thoughts related to the bill before I start diving into the 5 specific questions, or you could wait and weigh in one question at a time at your desire. Okay, very good. For those not hearing on the mic, she would prefer perhaps to do either, but maybe with a preference of one question at a time. That being said, let's start with the first question, and I would ask that everybody who's interested in weighing in on the question to please get close so we can make this move. Okay, question number 1. Yes, and if you could read your name into the record, that would be great. If you could click it on until you see a red light.
Can you hear me now?
Yes.
Thank you. My name is Megan Dillon. I am the Public Benefits Project Co-Director for New Hampshire Legal Assistance. I'm a non-attorney. I am certified as a non-attorney rep to represent claimants in federal disability claims, and I've been doing that with NHLA for a little over 10 years, representing both individuals and children in federal disability claims, overpayments, and termination matters. Just for a little bit of background.
Thank you very much. And I know you come very highly recommended. I've heard fantastic things about you, your work, and your knowledge. So we have the exact right person here if anyone has questions related to Social Security. Number 1, how many 4E eligible children are currently receiving SSI benefits, and what is the rationale for the anticipated loss of 4E funding? So would you like to have them start and then
Yeah.
you? Okay, could someone from DHHS please come, read your name into the record, and discuss the answer to that question? And once you do, we'll open it up to anyone else who has thoughts on the question. Ma'am.
Good afternoon. My name is Attorney Laura Young. I'm litigation counsel for Department of Health and Human Services. And so going into question 1, the department collects Title E benefits for approximately 25 children in lieu of SSI. And that's because we can receive more funding from that Title 4E than if we collected the full SSI for those children. So we're able to get more funding in that sense. The department, it also claims 4E funding for administrative costs that's allowed under the title. And we believe there would likely be a reduction in administrative costs connected to a reduction in overall taking 4E funds.
Okay, approximately 25 children.
That's correct. Again, I give the warning that we're dealing with a lot of in and out. I think you heard me say this last time, meaning we welcome that, right? We want kids to come in and out of our care in different situations. So when I say 25, that is not, again, a stagnant same 25 children. We're really trying to do our best to give you averages, even though that's very difficult. You know, we could have an influx next month of children, of an additional 20 children. We don't know what's coming. That's what's been very difficult for this process of answering these what seem to be simple questions, is that it's very layered. So it is 25, but again, that's considering the in and out and that we don't know what each day may bring.
Thank you. Ms. Dillon, anything to add to that?
I would just add that I don't think it is a fluctuating number. She said I can certainly understand kids coming in and out, but primarily we still don't have a good sense of how many of those children are actually receiving supplemental security income, SSI, which is a welfare or needs-based benefit under Social Security, versus Title II benefits, which are dependent benefits. So children qualify for Title II benefits only if a qualified parent qualifies for those benefits so they can receive them under the Title II. That means that A parent who is an insured worker who has qualified with their work earnings over time, their dependent child can qualify for a benefit under their record. There may also be survivor benefits, a deceased parent who is also an insured worker where the child could qualify for survivor benefits. Those benefits are not subject to income and resource requirements whatsoever, Title II only, and therefore there are very fewer reporting and administrative requirements for those types of benefits. You don't have to do an annual reporting for Title II. There's no impact on income or resource limitations for those students. For those kids. The only thing that would impact that if somehow the parent became ineligible and suddenly the child wouldn't receive that benefit anymore. That would be the primary impact on whether a child receives Title II or continues to be eligible for Title II, which is quite different from SSI, where there are more parameters around reporting because it's a need-based program.
And just for clarity, I know we both talk in Title II and Title 16, but just that's really, if when you're practicing Social Security, Title II, that is SSDI. Title 16 is SSI. I know, Megan, and we both speak that language. And so when we say Title II, Title 16, we're talking about those just for, to help out.
Very good. And may I remind you, Attorney Young, you said the word simple. No one else, no one here on this panel used that word. So that's yours. Okay. Any questions from those on Division 3 related to this topic? Okay. Ms. Rosenberg. Yes, have a seat, please.
Hi. Just for the record, I'm Karen Rosenberg. I'm the policy director at the Disability Rights Center. The question I would ask the department to pursue further is this assertion that if the department doesn't take the 4E maintenance payments, that they would also lose administrative payments. I'm not an expert in that field. I've been trying to get a handle on that information from other folks. So it might just be something helpful for the department to look further into, maybe get some direct guidance from US DHHS about that. It's just a question, really.
Okay, Ms. Young, are you amenable to that?
Certainly. I can look into that and get back. I don't think, just to be clear, it was a reduction, not a complete absolution. That was what we are thinking, but we can come back and look at that.
Thanks.
I would also just add one thing. When we're looking at the total potential loss in SSI benefits, the maximum SSI payment in 2024 is $943 per month. The statistical data from Social Security from 2022 that was reported, the annual report, said that the average SSI payment to a child was $685 per month. So the amount a child can get can vary depending on what other income resources or specific facts pertain to that child. So it's not clear also how many of those kids are receiving the maximum SSI payment or not currently.
Okay, thank you. Anything further? We're going to move to question 2. All right, question 2. How many additional 4E eligible children are anticipated to be found eligible per year for SSI benefits, and how did the department reach that calculation? Ms. Young, would you like to start on that?
Sure. We had these questions, ahead of time, and we tried to provide our best answers. This was something we did not feel comfortable speculating about at this time. We already provided the approximately 25 children right now, but in terms of how many could be found eligible per year, we could not speculate to that to give you an accurate number. We instead felt that hiring a consultant to assist with this and other questions would be the best in providing any kind of guess, because that's what it would be right now, is a guess. And we want to be very careful about that when it comes to funding, especially to just guess.
Thank you, Ms. Young. Ms. Dillon?
Yes, I would just say that folks should be aware that in terms of, I can't speak specifically to the 4E, that's not my area of expertise, but regarding SSI, again, according to the annual statistical report that was released by Social Security for 2022, there were approximately 1,617 kids meaning folks under 18 receiving SSI in 2022. It's a very small number. There is very, very strict medical criteria that a child must meet to qualify for disability under SSI. Primarily, they have to have a severe impairment or combination of impairments that is expected to last or has lasted a period of 12 consecutive months. And they generally have to meet a marked or extreme listing under multiple domains of functioning for children. That means that they assess how they perform in school, how they cannot perform in school, how they do self-care, things like feeding themselves, dressing themselves, capacity. Children have to be considered in two marked areas or one extreme to qualify for SSI. So it's very difficult generally for children to qualify for SSI. A diagnosis alone is not sufficient.
Thank you. Representative Wallner, followed by Representative Leon. Representative Wallner.
Thank you. Would you give the number of children again?
This was according to 2022, the annual statistical report from Social Security Administration, 1,617 in New Hampshire under 18 receiving SSI.
And I think just to be sure everyone understands, the bill only addresses children who are in state care, so this does not have anything to do with all
That's right. That's the
1,600.
total, not
Yes.
not considering children who are in placement or in care.
Right.
So that's the number for kids just living with their parents who may qualify or in other familial situations that are not in placement. So it just gives you a sense of how difficult it is for children to qualify and how many potentially out of the children that are filtering in and out of the system, the chances of them qualifying, meeting all of the parameters for this very strict medical total disability program are not high.
Thank you.
Representative Leon for a question.
It was very similar. It's answered.
Thank you. Ms. Rosenberg.
I just want to point out that my colleague from New Hampshire Legal Systems is here. She may want to introduce herself.
Good afternoon. Sorry. Good afternoon, Michelle Wongren from New Hampshire Legal Assistance, and I apologize, I'm a few minutes late.
Did you get that name, Mr. Clerk? If you could, for the
I'm
record.
sorry, it's
You need the
Michelle.
microphone closer to your mouth.
Here we go. Michelle Wongren. It's Wangerin.
So, and just to put this number that Megan was speaking about in further context, like in New Hampshire right now, there are something around 30,000 children who qualify for special education. So that just gives you an idea. And we only have 1,600 children under 8. And to qualify for special education, you could be under 22. So now we have only 1,600 children statewide under 18 who qualify for SSI. So it is a teeny tiny percentage of children that we're talking about.
Understood. Anyone further on this question 2? Okay, let's move to question 3. Ms. Young?
Oh, I wanted to make sure, given the 30,000 in the special education, keep in mind, just as Megan pointed out, this is a means-based program, meaning SSI, you have to meet certain income criteria. So I don't want you to take the 30,000. I absolutely agree. It is very difficult to get on SSI, but I just wanted to make sure that's clear as well. It is a means program, meaning you have to meet very strict income eligibility.
Okay, thank you for that. Question 3. How did the department calculate the $704,000 loss in 4E funds that was mentioned, as I recall, in the fiscal note? The fiscal note is shocking for many reasons. This is one. So if we could have an answer to that, that would be fantastic. Mr. White.
Good afternoon, members of the committee. Nathan White, Chief Financial Officer with the Department of Health and Human Services. The $704,000 was one component of the total impact that we would expect if this bill is to pass. There's currently 25 again, and I just want to caveat this figure as these numbers are constantly moving every day. For roughly 25 children, we would expect approximately about a little over $700,000 impact because we're currently claiming 4E for them. In the event we claimed SSI, and as we do today, where we do collect SSI, we use the SSI towards the payment for treatment and other services that those children would receive. So were we to claim SSI for those children as intended by the bill, we would no longer be able to claim that 700 and so odd thousand, and we would still have a treatment need. The children would still need services, and we would need to get general funds to pay for those services.
Ms. Rosenberg. Oh, I'm sorry.
Michelle. No,
Michelle.
Michelle Wanger from
Yes.
New Hampshire Legal Assistance again. One thing I would say about that is, so we're talking about 25 children here. And what I don't see in the bill is a requirement that the department not claim 4E funding. And I know that I previously circulated to at least some members of the committee an article about how the intersection between Social Security benefits, SSI, and 4E work. And the way that my understanding is that it works, and if there is another 4E specialist that knows something else, I'd love to hear that. But in the documents that I've reviewed, the way it works is that there's no bar on claiming both 4E benefits and Social Security. If you do claim both, however, and a child receives 4E funding, their Social Security is reduced dollar for dollar. So if the department were to receive, say, I don't know, $4,000 per month in 4E funding, which may be, probably in the ballpark of what they might receive for a child in an institution, their SSI would be reduced to zero. So they would still have the SSI on file. If they were to return home or to a less restrictive setting, they may receive it, but the department would still receive its 4E money while that child is in institutional care. And so if there needs to be a clarification that the department, at least for children in institutional settings where we know that the amount of $4E is going to be high, to clarify that in those situations, the department may claim 4E funding simultaneously with SSI benefits, I think that would be a nice clarification to make sure that the state is not losing out on those $4E. But again, there is no bar on claiming both, and it's the amount of SSI that is reduced dollar for dollar, not the amount of 4E benefits. Now, of course, we know that these are children with extraordinary needs. And, one might argue that being in institutional care recognizes that that is an extraordinary need. At the same time, when you're talking about a child in foster home, those extraordinary needs are still present. And so when we're talking about kids in foster homes, where the amount of $4E claimed by the state is going to be less, we would honestly like to see those children receive their SSI dollars so that the foster home has access to meet their extraordinary needs. Might they need some specialized care in the home? Might they need specialized therapies and that sort of thing? It would be really nice to see those children have access to those dollars to meet their extraordinary needs. But again, I believe, and the department can please correct me if I'm wrong, that the vast majority of those $4E come from children in institutional care, not children in community-based settings. And again, as the bill is written, even for children in community-based settings, there would be no bar on the state claiming 4A funds under the bill as written. There would just be that dollar for dollar reduction.
Okay, Representative Edwards.
Thank you. I think you may have actually answered my question in your very last sentence. It sounds like the answer to number 3 on this question document. Do you have that in front of you?
Yes.
Okay. That if we can apply simultaneously for the 4E money in addition to the SSI, that the answer to number 3 may actually be different.
It'd
That
be
we're
zero.
it'd be zero. So instead of 704,000, we'd be talking $0.
Zero.
So no loss from
No
that.
loss.
Mr. White, may I? Yes. Mr. White, do you have an observation on that?
The challenge is we can't, and this is based off of our understanding and coming from decades of experience on the financial team that have historically managed this. Historically, our understanding based on our conversations with our auditors is that we're not able to claim both, which is why we're basically seeing some general fund impact. And I think what's really important here is not to focus necessarily whether it's the 704,000 here or the 1.4 million, the other impact for the total 2 million is from a policy perspective, we are going to have some impact on general funds. And again, I'm speaking of it, I'm speaking at this through the financial lens. Whether it's $1.5 million general fund hit or a $3 million general fund hit, depending on the year and utilization, we will have some impact. So whether it's 500,000 this year and $1 million the next year, you know, ultimately what this really comes down to is we know we'll need additional general funds, and we know this is a policy decision. I just kind of want to level set the floor with that statement, because when we don't know, for example, when we start to prepare our budget for the next year, this coming August, which we'll submit in September, we'll be making certain assumptions about utilization. We'll be making certain assumptions about what we'll need in federal funds and what we'll need in general funds. And so I know that we're getting very much into the weeds and details here, but I think it's important not to lose sight of the big picture. Ultimately, it's a policy decision that will have some impact on general funds, and we just don't know how much. This is our best estimate based on the information that we have, which isn't necessarily kept in our financial system for this type of analysis, which is part of the reason why in question 3, we were recommending some type of further analysis relative to this, because this is the best information that we have available.
Representative Hole.
Thank you. You mentioned that you had spoken with the auditors on this, and they led you to believe that you could not concurrently ask for both funds. Is that a document that was put in writing anywhere that could be supplied?
I tried to to clarify, Representative Hall. I tried to contextualize that within the experience of the team. So John and I, we've been having conversations with my deputy CFO, who has 27 years experience working in this area and is very well versed. And it's her understanding, based on those years of experience, that we cannot claim both. However, we're more than happy to try to examine that further. But in the event that, you know, maybe if you could claim $1 of SSI, but you may still have additional 4E, that would probably just be a further administrative burden. So we would just need to recognize that. But that's how we were interpreting this to date.
Follow up.
Thank you. If there was a chance to ask the auditor that presumably the auditors coming out of the federal government that you're working with, no?
So the auditors, the legislative budget assistant hires the single statewide auditor that has historically been KPMG.
Ms. Dillon, your mic is on. Did you have further information?
No, I would just point out again that in terms of, I don't know what in terms of the auditor is saying, but for the purposes of children collecting SSI and SSDI benefits, as long as they're within the parameters of that income limit of that 943, they can collect both. So most of the time, those Title II benefits, the benefits they receive under the record of a parent, would be significantly lower, allowing a child to collect both benefits at the same time. And for the purposes of the 4E, I can't imagine what other bar would exist other than meeting those income and resource requirements to collect both benefits. I haven't seen anything that would prohibit it otherwise. My kiddos have received other forms of payment. Sometimes a parent qualifies for a pension that's below the 943, and they can collect that on behalf of the deceased parent in addition to their SSI benefit. So as long as it's really the financial barriers are the only thing that prohibit SSI recipients from claiming other benefits they may be qualified for.
Yes, Representative Edwards.
Okay, so it's outside of the boundaries of what we're trying to do to get ready for a vote on this bill. But it does seem like maybe for the good of the state, if Mr. White can get whatever documentation that indicates that we can claim or ask for both, that may improve our own collection services internal to the department. I'm not saying it will, I'm just saying it might. So if we could just double check, because that sounds like, we could fund some of these other bills with the 704,000. So it is kind of relevant to what we're doing.
Mr. Chair, I just like to, I really appreciate that question, and I do think that it's probably a pretty simple answer, and I would just want to caution the committee against spending $200,000 to get the answer, because I do think that that's a basic statutory question that I would like the department to investigate prior to delaying the bill in any way, spending $200,000 to get the answer to that question.
Ms. Young, do you have a comment?
I of course disagree. I don't think it's just answering that question. And I also think you have multiple people who work with this, and we all understand this Title 4E a little differently based on our experiences. This is not a simple statute to read. There is nothing simple about Social Security. 4E is part of the Social Security Act, just so that we all know it's all part of Social Security. So I think what getting a consultant gets you and gets the advocates involved in this is the best answers that we can give, not only on funding, but on what we can do maybe even better than we're doing now, and what we can do to change policy in a good way that serves the kids the best we can, and in the best way with the best possible funding, whether it be more or less. That's what the consultant can look at and see. I think even answering these questions, you're seeing this, that shows how much thought has to go into this and how much limitations we have right now on this timing to do that. And so that's why we feel the consultant to come in and help us and help the advocates involved as well get the answers, get them right, and let us do a good job if this is going to be a policy change.
I just want to add one thing, which is that I think that it's interesting to note that even currently, under current policies and under Social Security regulations, the department is already required to account to the Social Security Administration about how the children's Social Security benefits are spent. I think that the department already has people on board who are effectuating this responsibility. And if it comes down to, I think my understanding is that it's possible to claim both, and it's just going to be a reduction in the Social Security benefits for children on SSI. But if that's not true, and it's not feasible to collect both SSI and 4E benefits, there's probably a pretty simple fix that could be put into this bill that would exclude the requirement that the department take SSI benefits during the time that the child is in a residential institutional placement. I think we could all come together and probably come up with something that would meet that concern. I think we just need to know the answer to the first question.
One question to look at might be, we're talking about the kids that are coming in and there's that application. For the kids that are coming in that are already on SSI, is the department taking them off SSI to claim 4E, or are they just getting that dollar for dollar reduction now? Do we know?
Probably something to be looked into. Thank you. Representative Edwards.
The question for the chair. It seems to me like we're learning things that would allow us to put forward an amendment to this bill that would improve it some. And so if I'm hearing this right, do we have a legislator in Division 3 that is taking the lead on working with the folks, much like Representative Wallner is on the other bill, to try to create an amendment? It's a tasking issue, a delegation issue. Or do we have anyone identified who wants to own an amendment?
I believe that the answer to your question is I don't know of any right now. However, Representative Wallner is the prime sponsor. I'm also on the bill. I'm sure we can work with all of the parties here to create such an amendment that you mentioned. That being said, we've been at this now for almost 40 minutes, and we do have other bills on the docket. My intention is to go through the next two questions, with that being said, in the similar manner that we are now, and then rescheduling this for the follow-up items that we have discovered along the way, as well as any particular amendment language that we come up with for the next work session, or perhaps even one after that. Okay, we're going to go now to question 4. How did the department calculate the $1.4 million loss in federal SSI revenue, also in the fiscal note? Mr. White.
This was the actual SSI revenue that was earned in state fiscal year 23. For the initial fiscal note, the department actually received, I think, about 160 fiscal note requests this year, which was a record, and we had about 5 days to turn those around. So we tried to provide the best information possible in the initial fiscal note. This is the updated, revised fiscal note here. And again, this is based on the actual state fiscal year 23 revenue. Were the bill to pass, we would need an equivalent amount of general funds to maintain that in state fiscal year 26 and each year thereafter. So,
Thank you for that. Any follow-up or thoughts, questions, anyone around the table or in the center? Okay, moving on then. Question number 5. What are the specific additional obligations triggered by this bill beyond DCYF's current obligations under department policy? And what are the expected duties of each additional needed staff member? Ms. Young.
Yes. So today we deal with those children coming in who are already receiving a benefit. This bill would require us to determine whether or not children who do not currently receive a benefit would be eligible, and then take that a step further and safeguard it. And then it also requires that every year thereafter, should it be a child that remains in care. What that goes into is, right now we have an accounting process and that's required by Social Security, and it goes to cost of care. You've heard us say that. So that's in and out, right? The difference would be, as a fiduciary of money coming in that is not in and out and going to cost of care, you're dealing with fiduciary decisions. That is not a simple task, and it looks different for every kid. Those fiduciary decisions could be a daily ask of what needs does that kid have. It could go into protecting those needs, protecting the needs, putting it in a trust, putting it in an account of some sort. That does not absolve any kind of fiduciary decisions. That requires a monitoring process of making the decisions. We kind of talked about that at the last session, so I don't want to get into those details. But also, it requires that for the in and out of making sure that new kids come in, eligibility, we have to decide what's going on. That could easily change from day to day, from kid to kid. It also can change given the kid's circumstances. I think we talked about how difficult it is to get on SSI. That could be a difficult road in terms of appeals, and having an attorney that is monitoring that, making sure it happens. It also could be someone, a staff person, monitoring when a kid gets into care and gets the care that they need. That means we have evidence to go forward with Social Security, and that takes quite a bit of work as well. So what we looked at when we determined the staffing for this was all that combined. If we have kids going in and out, we have kids that are going to need daily fiduciary decisions, daily safeguarding decisions, and then also decisions about who can manage those trusts. For example, is the state going to be a trustee of a special needs trust, or are we going to be able to find someone else, be it professional or a family member? And those are not easy decisions. I think we have all seen cases of things going wrong with fiduciary duty. And it is not a light decision-making process. And so we have purposely staffed it in a way that we can make sure that we know where the money is, where it's going, and that it's going properly and being safeguarded. And that's really what we see the staffing. When you have a legal, you need an attorney to do that. You have to have an attorney that knows not only Social Security law, but you have to have an attorney that knows probate, for example, and fiduciary duties. And then on top of that, staffing that attorney with paralegals and staff that can continually monitor the children in care. Again, think of this going in and out, and making sure that is being taken care of. And that's the best we can do to kind of give the committee the big picture of what we were thinking when we staffed this very purposefully, very heavily, because of the heavy fiduciary duty involved.
Representative Hole.
Thank you. So in a hypothetical scenario, you have a child who comes into the system, right, and is eligible for Social Security benefits, and then for some reason, whether it was a temporary illness, temporary medical issue, whatever drove them into that state, they are no longer eligible a year or two later. But if they were at 6 at the time, are we still managing those funds up through the time they're 18 before they have access to them? How does that work
Are you talking about right now or under this bill?
under the proposed bill?
So under I just want to make sure I understand the fact scenario. So we have someone who came in who was receiving SSI.
Correct.
They now, probably thanks to Social Security and continuing a disability review, they're no longer eligible.
Correct.
That's right. So now we have to find somewhere for that money to go that we've safeguarded.
Right. And you hold on to that until they're 18? Is that what the plan would be?
The bill envisions safeguarding that for benefits purposes. In that, it would really depend how much money was involved. We want to have to be really careful about, for example, Medicaid benefits, not having too much to that kid's name. But yes, the idea in this bill would be that the state safeguards it by either putting it into some kind of safeguard account, as long as they're disabled, at that point that you make it, or receiving it, yes, and holding it until they're out of care.
Okay, Representative Edwards was next. Representative Edwards.
So this last sentence in the answer to question 5 is the one that leaves me the most concerned, where it says that the complexities of managing trusts and other unique accounts will increase workload. I don't think that we do anything in this area currently from a state's perspective of administering accounts for our citizens. And if that's true, if it's not true, you correct me. But if it is true, it seems to me like we have to invent almost a banking branch to do this, and making sure that we identify all of the federal and state laws that we would now have to comply with. That seems like it would need to be done. And then the policies and procedures and the training and the hiring, this just seems like a massive part of the bill that I'm sort of just concerned that we do not underestimate. Do you have any comments on that?
I think that is accurate. I will say we do have state institutions that have personal needs accounts. I think of, for instance, Glencliff Home. If someone is on Medicaid, which Glencliff, I believe almost everyone's on Medicaid, they get I think it might have gone up to $90 a month that they can keep, for their account. So I will give that caveat that that is a state institution. So technically we do manage those funds, though they normally have a guardian that does so in terms of having a collective state account. That's the one I thought of after we met last. But yes, this would be the state getting into the fiduciary services business, which is different than what we do now.
Different in the sense that it causes us to need to comply with additional federal law? And if so, do we just think that, or have we identified new federal law we'd have to comply with?
We already act as fiduciary in terms of personal or as representative payee for those kids. Like we talked about, it's in and out though, right? We have regular audits with Social Security for that right now. So we meet that. We would have to meet that again as an organizational representative payee, but it's different. It's not just in and out. So we would have to meet those regulations. In terms of others, you heard me talk about meeting Medicaid, making sure that Medicaid funding, that those dollars are safeguarded in a way. And I have to come back and think about the different, you asked about federal, but then we also have state expectations of our probate court system, that it's a question of whether we would have to open a guardianship of the estate to even be able to create a special needs trust for a kid. Because right now it's guardianship over the person. That's really, you think about over the person is, where someone lives, medical care decisions of a kid. Now we're getting into financial decisions. And I think we would open up a world that the court would be very mindful, because these kids are under the jurisdiction of the court in terms of guardianship if they're in care for the most part. We would want to make sure that we're in line with that. I do not know, I know you mentioned bank. I do not know if we would be subject to any kind of banking or anything like that. That's something I'd have to look into.
Thank you, Madam Chair. Thank you for the answer.
Thank you. And Ms. Rosenberg?
Michelle wants
Yeah.
to take. this one.
Oh, I'm sorry. It looks like,
we're
Yeah.
fighting over it.
So, Madam Chair and members of the committee, I think this is becoming incredibly overcomplicated. I think it's important to remember the state receives these benefits, becomes the representative payee, and is already the fiduciary. They are already responsible for using or conserving these dollars in the best interest of the children. They are currently making a choice to reimburse themselves with it, but they could make a choice to use it for the child's day-to-day benefit or conserve it. That is no different. They are already a fiduciary, and any of the legal responsibilities that come with that are already on them. The choice is reimburse themselves or use it for the child. And so the way we envision this, if we're using it for the child or conserving it for the child, that it would go into a dedicated account, just as they already do with retroactive benefits that a child may receive after they become eligible for SSI. Where they're already managing specific accounts for the benefit of children. We see this working very, very similarly, where a JPPO could say, or a child protection worker could say, this child just broke their glasses for the third time this month, and insurance isn't going to cover it. Oh, well, that's a good use of this money, and there's an account for it. Or this child would really benefit from equestrian therapy. Oh, there's a dedicated account for that. So we don't see this as being this complicated process. We don't see this as increasing the state's fiduciary obligations that they already have. We only see this as ensuring the money is either used for the child's benefit or conserved for the child's benefit instead of reimbursing themselves. Their legal obligations do not change. What they would have to decide is where to put that money. They could do a special needs trust, but that's a more complicated, expensive process. We have ABLE accounts in New Hampshire, which are a much easier process. Would somebody have to manage the withdrawals from them? Yes. And so could I see, for 100 or so kids, could I see an FTE maybe, taking requests for this money and managing, approving or denying each request? I could see that, but I could see that for one staff. I don't see that for 6 or 7 staff. I think this is becoming massively overcomplicated in a way that it just doesn't need to be.
As a reminder, this legislation is modeled after Arizona law. Is that true?
Yes.
Do you know how many administrators manage their accounts? Perhaps a question.
We can
could be
look at
answered
that.
I
later.
remember looking at the fiscal note.
I have it.
And it was like 2 or 3.
Yeah.
It was fewer. And it was, I think, for like 1.5 million kids. I do remember that number, that the amount of kids was in the millions.
Representative Leon.
Thank you, Madam Chair. This is definitely a complex topic, but as somebody who is licensed by the SEC for far too long, the idea that managing the funds in one way is the same as managing the funds so that they can be taken responsibly to these children as they're out of the system, just brings up all sorts of red flags to me. That management of preserving their assets and their capital for their future opportunities is entirely different than managing it for their current custodial care. year as part of the state. And I can't tell you all the details of it, but my red flags from all my SEC work really has huge minefields for this. So I think we need to make sure that we understand just what liability the state is taking on managing these funds for these children.
Yep. Megan, I was just going to say, could you explain how the reporting obligations work?
So just to your point and to my colleague's point, I just wanted to say point blank that the state is not obligated to take on the fiduciary responsibility for reporting and be the representative payee for these children. In fact, the Social Security regulations and the POMS manuals make the state organization or welfare agency 6th or 7th in the preference line for being the rep payee for these children. I certainly understand that there are situations where maybe the child has no kin whatsoever, that it's appropriate for the state to do so. But in most instances, a child may be in care and still have a very competent relative, aunt, uncle, adoptive parent, or whatever the situation may be, that could manage those funds for them. Becoming a representative payee is specific to Social Security, and you apply to become a rep payee. So the state does not have to do that, and the Social Security Administration has an obligation to vet, find, and appoint a representative payee. That is the federal agency's responsibility, not the state's. So they could choose very much so to put the onus back where it belongs on the federal agency and tell them to find appropriate payees for these kids, many of which may have a vested emotional interest in that child as their relative or relative's friend or close family member. And that's completely possible. And we would eliminate a lot of the responsibility and the cost associated with managing those reporting if that's done. And that's something that could be done. In addition to that, the reporting responsibilities, again, when we're talking about children who are recipients of Social Security disability insurance or a Title II benefit versus supplemental security income, are very different. Again, Title II benefits don't require annual reporting. They are not an income or needs-based program, so the reporting is much less or not required in the same way it is for SSI. And for most SSI kids, a representative payee, and this doesn't apply to parents or relatives who live with the child anymore, are not required to do an annual report. A state agency or a welfare agency would be required as the rep payee to do an annual reporting. It's an online reporting tool. As long as they are tracking how the child's expenses are being used, it can all be submitted at once in a one-time annual report. There can be changes that can occur for children in care, which I certainly understand, like an address change or a name change or something else that needs to be reported. But again, that seems like a low lift in terms of reporting. We report changes for clients, and it's an online tool. It's simply a written statement to the agency. The address is now this. It just doesn't feel as cumbersome in the way of, for this many kids, and especially if they didn't have the responsibility. This is a voluntary responsibility that the state is taking on to be the rep payee. They don't have to be. So in that way, and for kids, you're talking about a lot less that's involved in the annual reporting. For adults, it's a lot more complicated because adults may be going back to work. Adults may be doing more things that can have impact on resource and income, opening their own bank accounts that maybe other people aren't aware of. Children need adults to do all of this for them. So the fact that things that are harder to report for adults because they have the authority to do it themselves simply can't be done for kids. So that reporting is not as intensive. So for all of those reasons, primarily thinking that the state should strongly consider putting the onus back on the federal agency to find appropriate rep payees for these children and simply not choose to take that responsibility on. If the rep payee is appropriate and can continue to be appropriate, then that should happen.
Okay. All set? All right.
One thing, I also wanted to call your attention to some policies that Michelle Longerin distributed at your last work session. So the Division of Children, Youth, and Families Policy Manual 1676 if you go to page 3 of that, this is the section that requires them to establish a dedicated account for any child who has 6 months or more past due benefits. This comes up pretty frequently because the Social Security Administration takes a really long time to make eligibility determinations, but they already have a process in place to make decisions about how to use a child's funds to meet their extraordinary needs. So, and it lists, what the process is for creating a dedicated account and what kinds of items can maybe used from this dedicated account and what the reporting requirements are for that. So the division already has a process in place. Thank you.
Likewise, I would just say I heard earlier that one of the added obligations is an application for benefits for all children coming into the system, and currently they are only receiving the Social Security or SSI benefits of children who already receive them. Again, I'd just like to point the committee to that same section of policies which also already requires them to apply for Social Security benefits or SSI benefits for any children going into out-of-home care, which is exactly in line with what this bill requires. Whether or not they're doing it, I don't know, but they have a policy that requires investigation of eligibility for each child going into an out-of-home placement. And again, this bill only requires an investigation of eligibility for each child going into care, which I perceive means out-of-home placement, but assuming those are in line, the policy is in line with the statute already.
Yes, Ms. Dillon.
And I would just point out one more thing. As far as the annual screening and medical redeterminations, once a child is found eligible for SSI benefits for themselves in terms of their own medical impairments that qualify them, Social Security will review that child not less than every 3 years. So every 3 years is the maximum period of time that they're going to look again to see whether that child qualifies for continues to qualify medically for that benefit. Unless there has been a major medical change reported or major medical improvement, Social Security is not going to look at that medical eligibility again until about 3 years from the time the child is approved. So I'm not sure that any type of annual screening medically for a child would be necessary at all unless there is a major medical change that you think now qualifies the child for disability that didn't exist at the time that they entered care.
Okay, thank you for that. Anything further? We're still on question 5. Okay. That was a jam-packed almost 1 hour of House Bill 1598. So I want to thank everybody for, first of all, their time. We are very mindful on this committee as to everybody's time and how valuable it is. And we try to go as fast and be as concise as we can. And sometimes that doesn't always work out. But always know our intention is the same, and that is we truly appreciate everybody's time and expertise in sharing information to help decisions be made appropriately. So again, thank you. There are some items that are for follow-up. For example, question 1, further data from the U.S. Department of Health and Human Services. Question 3, whether or not 4E and SSI, if there's a bar on both, isn't there? Also, there was a request for a dollar-to-dollar comparison on question 3. Those are just some of the follow-ups I have. Arizona personnel on question 5 was another one. Yes, Representative Priest.
Thank you for taking my question, and I apologize for not being here earlier, but I was double duty today. I would appreciate written responses from HHR on the questions that were discussed today. Thank you.
Thank you for that, Representative Priest. I believe we have that already. If you, Ms. Young, would take it upon yourself to either email what has already been emailed to me, those answers to all of us as they are, or if there are amended versions to those answers based on today's discussion, whichever one you choose, could you be the person to email that to all of us here on Division 3?
Yes.
Thank you. Okay. So, anything further from the members? All right. At this point, I'm going to close the work session on House Bill 1598 with the full intention that this will be rescheduled to another work session through our Division 3 chair. Thank you all.
Nice work. Thank you. So there are 3 things I still want to do before wrapping up, and I want to, just for the everyone on the panel to know that I want to impose a hard stop at 4:15. Why 4:15? Because we should be out of the building by 4:30 to let Janet go do her stuff. And I want to give each of the caucuses a chance to talk a little bit before we leave the building. So we'll a hard stop at 4:15. Caucuses will meet or not meet, whatever they want to do. And so the three things I want to do at this point is I want to bring up Mr. Wieters to have us hear what he has to say about the IT implications on any of the effective dates of any of the bills that we've heard or will hear still today, which the only one we haven't even mentioned yet is 1588. So go ahead.
Okay, for the record, again, David Wieters, Information Services Director, DHHS. Chairman, if I may, 1669, can I address the IT components for that one?
Yes, you now have the floor.
Okay. So we addressed all the bills with the exception of HB 1669 and HB 1588, from what I can tell. But if you need additional information, let me know. For 1669, we, based off of the current fiscal note that you have in front of you that's posted, we don't need additional funding other than what's already listed there. And we would be in compliance after 60 days of passage as it is written today. The reason why is we currently do not share data with other states from the New Hampshire Immunization Information System. As of today, we do plan on sharing data in the future. And in order to do that with the changes in this bill, we would need the funding to do those changes, but we would not share any data until such time that the changes were made. Additionally,
Okay, so if this bill didn't get passed and we didn't give you money to change the system, would that mean that by default we would not be sharing with other states or regions?
it would mean that we would be able to pass administrative rule to manage how we share data, but it wouldn't necessarily mean we would comply with the letter of the bill as written. So we would manage the administrative rule to share data with other states, as other states do for immunization information system data. But the specifics in the bill would not necessarily dictate how our administrative rule is written.
Okay, and then if you could just remind me, is this immunization system, is this the anticipated answer to the question that's been coming up for a couple decades now about having an immunization registry? Is this the long sought solution to what has been an ongoing aspect of discussion in the legislature about having an immunization database? And welcome, tell us who you are so that we get you in the record.
Hi, Chairman Abby Rogers, Legislative Liaison for the Division of Public Health Services. I'm here to support with some information on the immunization from the immunization program if you have questions. So just to fill in that eventually IISs or immunization registries do intend to share with other states. That's sort of the best practice. New Hampshire currently does not do that. And it is not a priority for the department to currently do that.
Are you familiar with the ongoing discussion for about 10, 15, 20 years about our desire to have an immunization database, and we haven't had an IT base? And so this comes back to my question to make sure that I'm in line with what I think I'm talking about. Is this the answer to the 20-year-old question about us needing an immunization registry?
Clearly, the immunization registry is critically important. It is.
Is that a yes or a no?
Well, I'm not sure exactly what you're getting at. If you could rephrase the question. The immunization registry is very important. Certainly, patient health records in the immunization registry sort of travel as they would like a patient health record. So if you went to college in New Hampshire, for example, you might want to have your, and you move back to Maine, you'd like to have your electronic records transferred. We currently don't do that. I think immunization registries are moving in that direction, and I understand that this bill is an attempt to add a waiver process in, if similar to the one that we have in New Hampshire, which allows people to opt out of the registry or withdraw their information.
All right. Did you have a question?
Thank you, I did. So your timeliness on the answer regarding opt-out is profound, or it is apropos. There was a desire to change from an opt-out database to an opt-in database. Do you have any information on where in the process that is?
Sure. HB 1606, which accomplished a sort of an opt-in, opt-out for the immunization registry, passed in 2022, and the department is in the final process of filing our rules based on HEP 307. Our final filing on those rules to update the legislation are going to be filed at the end of the month, and we have reviewed those rules with Representative Leon as well in January. Thank you.
Follow up. So for those who were inadvertently swept into the database the first time and don't want to participate, what happens to that data?
So there are options to withdraw that data. When the bill became effective in 2022, basically it's a prospective bill. So moving forward is the intent of the legislation as far as withdrawal. But withdrawal is certainly an option for anybody's data who was entered in without the ability to opt out during Emergency Order 19, I believe it was.
Okay, one more follow-up. So what happens, someone says they withdraw from the database. Is their name there and it just says withdrawn? What information is left behind as residual, or is it completely deleted and they are no longer tracked whatsoever?
Okay, so the best that I can answer that question is I don't work for the immunization program, but I know that the department, as a provider for the immunizations during the state of emergency, under HIPAA have to keep information for 7 years as a provider. So my understanding that information is taken out of the registry and is held in a complete HIPAA compliant area, paper files, until that 7 years is up, and then those records are no longer with the department.
Okay, thank you.
Thank you.
So Representative Leon, did we get the amendment from OLS?
We don't have an official amendment, but I have the language that I sent, so I can give that to you guys so we can take a look and see.
I'd rather just wait and distribute what OLS gives us. So we can probably just anticipate deferring 1669 for full action next week.
Yes, the point of the amendment was to, instead of saying that the department shall not share it, would be simply to state that prior to entering into an agreement to share it, then the department would need to follow these procedures. That way, we're not burdening the budget this year with the need to do this and build up this infrastructure when we're not certain as to when they would actually look to share this information, given that it's not a department priority. So I don't know if that would change the IT requirements if it said that prior to entering into an agreement, you need to make sure that you will be able to actually follow the withdrawals and that are allowed. Basically saying that you won't share it until you're going to follow existing state law. Would that change what the IT requirements would be for this bill and the fiscal note?
Yes, essentially that would make it so that the IT requirements would be outside of the bill. We would still need to change the system and incur costs. It just wouldn't be associated with the bill at this point.
As a follow-up? So as a follow-up, that actually would just be capturing some of the costs that came with the previous House Bill 1606 within the withdrawal, that it wasn't necessarily handled within the build out of the IIS, that you'd be able to withdraw that information, not just within the state, but from the IIS.
So the best I can answer on that is there are, I believe it's a very delicate system. It's very, there's a lot of technology upgrades and testing and implementation, ongoing maintenance. So referencing in the bill as opposed to, I mean, the bill as amended still did require $80,000 sort of enhancement. We could get back to you probably on how the amendment might change that, but I can speak that I can imagine that it may need, once you do implement data sharing with states, you will incur the cost.
Sorry, and then one last follow-up. Do you need statutory authorization to share that and enter into those contracts to share that information with other states? Or is that something that is, if you could let me know where that's delegated to allow the department to share that information without coming to the legislature, I'd be very interested in that.
Sure, I believe that a lot of our contractual data sharing is through an MOU or an MOA, but I can certainly get back to you on that information.
Thank you.
MOU.
So Mr. Wieters, I stopped you as you were rolling out your longer answer. And if you could just focus on, based on your analysis, are there any other bills that we should be changing effective dates so that you can fully implement the system and support the policy? Or are there any changes to the dollar estimates? If you could just focus us on, yes, there are changes, or no, there aren't changes.
Sure. Certainly, Mr. Chair. Thank you. The only other one would be HB 1588. We would have a request for a change for effective date as a result of a change to a system.
Go ahead and tell us what that is. It's probably in your write-up, but.
So for HB 1588, in order for the department to be able to make the changes effectively, we would need an effective date of July 1st, 2025 in order to go through the contract amendment, the contracting process,
Yeah.
and do the design, development, and implementation associated with it.
Okay. So that change in the date doesn't change your financial need.
No, it does not.
All right. Anything else on the IT area?
That is all I have today.
Okay. I appreciate the extra work you put in on this and coming back and sitting here for so long today.
Thank you for the opportunity.
Are there any IT questions? Go ahead.
I just wanted to say that the actual amendment is up there. I'll grab the printed copy just so that people have something to work to before you come back to 1669. I should step out.
Okay, or we could just email it later, because I don't think we have time to deal with it today. So it's not time sensitive, but thank you. Okay, well, thank you. Thank you so much. So, I effectively ended 1669 for today, and we're going to go ahead and probably try to wrap it up Monday with the amendment. And then the last one that we have to talk about is 1588, relative to court jurisdiction over persons receiving special education. Have we ground everyone down? Is there anyone in the audience that wants to talk about 1588? Is there anyone in Division 3? What was our issue here? My notes say this needed two or three additional DHHS employees. It assumes 32 new clients, and somebody emailed us saying it's probably really 22. And then the fiscal note was rather broad, from 1.65 million to 5.76 million. And so, Mr. White, if you could tell us what you think about the clientele number and if the range on the fiscal note is any tighter than you thought.
Sure. So I am not as well versed on the specific population, but in the fiscal note, as introduced, dated 12/12/23, if you turn to the second page of the fiscal note, you will see the range that the chair is referencing there. And we're assuming that because we're expanding the eligibility by a year, we would see an increase in the total population. And as a result of that, we would probably see potentially the ranges of residential care, foster care, community-based services within some reasonable degree. And so you'll see there for state fiscal year 25 for residential, a low of 915, a high of 915,000, a high of $4 million. We also have a few additional position costs related to child protective service workers and one JPPO position, because we're assuming if we're expanding the population, we're going to have some additional caseload impact going forward, which is why we included those 3 position costs there as well. Similar to the last bill, there's a lot of variables here. We don't necessarily know who's going to age into the system, but we know that there'll be some impact. So we basically just straight lined linear the costs for this year into the years forward.
Thank you. Question?
Yes, thank you, Mr. Chairman, and thank you. Does this bill essentially move the costs that are currently under local school boards and local taxpayers into the department when you look at this residential, or am I completely misunderstanding this?
So there are situations in which the LEA will pay for residential, but I think that's specific to the educational component. But then there are cases where children are either in under child protection or coming through the Division for Bureau for Mental Health, where those children are being placed into residential treatment facilities. So you will have children at residential treatment facilities potentially being paid for by the state or an LEA, depending on the particular situation.
So if this doesn't pass, who pays for the $4 million or whatever the fiscal note is here? Because are these kids being denied services or right now, or are they being paid by somebody else?
So this is extending the eligibility age from 21 to 22. So we're expanding the population. So if this doesn't pass, there's no new cost. If it does, this is the estimated range.
Sorry, and the last follow-up is we increased the age for special education in the schools to 22 from 21. So the previous 21 years of age in this would have been a consistent age with the educational requirements for special education and for these payments. Right now, is there a gap where there are students who are paid by the department, except for that year from 21 to 22, when it bounces back to local taxpayers? Because I know in my town, we had a significant jump in costs from that increase from age 21 to 22.
I'm not as familiar with that discussion. I'd have to go back and get an answer for you.
That would be really helpful to understand what's happened to this change from 21 to 22, who's paying now, and if that makes sense to move it to the department, even if it is large and not budgeted.
Thank you. Any other questions for Mr. White or on this bill from Division 3? I have a question for you, Mr. Ripple. Could you go ahead and get an amendment on this to change the effective date?
Sure, yeah. So that would be to July 1st, 2025?
Yes, sir.
Okay, yep.
Okay. All right. So I'm hoping that'll be ready to exec next time we get together. Any other questions? If not, I'm going to go ahead and conclude the hearing on 1588. And then just some closing remarks. Thank you, Mr. White. Okay, so we're going to meet again as Division 3 Monday afternoon. We've been starting at 1 o'clock, and today I sort of felt like if we were trying to exec some of these things and still had open hearings on some of these things, that we don't quite have enough time from 1 to 4:30. And that may be because I talk too much or just go so slow. I think it's because these are complex issues, but so is there anyone who would have a heartburn starting at noon Monday? You just come fed and we'll take a potty break instead of just marching everyone through it like we did today. Okay. And then I'm going to, after I convene, I'm going to ask the Republicans if we could use your office, Mr. Chair, to see where we're at and, talk about what we think we might be ready to exec next week and what we think is still a work in progress. So Representative Wallner, I'm sorry, I'm interrupting you. Okay. At some point, if you could have a conversation with me about what your thoughts are about which bills are going to be ripe for execing, and obviously the ones that aren't ripe still have open issues. Okay. All right. Anything else for the good of the community? Mr. Secretary, you got everything?
Got it all.
Got it all. Got it all. Hey, great work. 3.5 hours of this. That's super. Okay. So, Mr. Ripple, final words of wisdom? Okay. With that, Division 3 is done for the day, adjourned.